Assemblywoman Cohen is also with us today. Both of them are playing substitute for other members that were not able to attend. So with that, Ms. Jacobson, please call the roll.
Senator Harris.
Here.
Senator Krasner.
Here.
Senator Scheibel. Assemblywoman
Here.
Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblyman Gray.
Good morning from Tornado Central.
Assemblyman O'Neill.
Here.
And Chair Miller.
Here. Thank you. And with that, we do have quorum. I would just like to address a few housekeeping issues before we begin. As you know, agenda items in interim may be listed in an order but taken in different order. We also may have 2 or more agenda items that are combined for consideration. And we also may have an item be removed from the agenda. Also, meeting materials can be accessed on our committee's webpage through the Nellis website. You can also sign up for electronic notifications of the happenings in the committee through the legislature's website. Committee members will be using their laptops, and of course we have some that are attending virtually through Zoom. So please don't take us looking down at our laptops as any form of distraction or disrespect. It is actually working and researching. Also, those that are on Zoom, please make sure to keep your cameras on so that we know that you're still with us and that we have quorum. We will also take a 30-minute lunch break sometime in the afternoon. With that, I would also like to ask everyone to turn off their electronic devices, any alerts or buzzards or anything like that that can make noise and be distracted to others. Our first agenda item for today is public comment. So I would like to open it up for public comment. In interim, we do have public comment at the beginning and the end of the meeting. For those wishing to call in to make a public comment, please dial 888-475-4499. And when prompted, the meeting ID is 890-323-8744, then press pound. Broadcast and production services will indicate to you when it is your turn to speak. You also may submit written comments. You may submit them electronically by emailing them to judinterim@lcb.state.nv.us or mail them to the Research Division at 401 South Carson Street, Carson City, Nevada, 89701. And also, we do ask everyone to try to limit your public comment to 2 minutes. Of course, sometimes we understand that people have a lot more to say than those 2 minutes.
What's happening? It's not.
So, I'm not sure who that is, but whoever it is, can you please mute right now? But with that, if you have more than 2 minutes worth of information to share with us or comments to make, again, that's a perfect opportunity to send all of your comments to us in writing, either through the mail or email. And so with that, I would like to go ahead and open it up for public comment, starting here in Las Vegas, if there's anyone wishing to make public comment. Not seeing anyone. Do we have anyone in Carson City that would like to approach and make public comment?
Good morning, Madam Chair Miller and members of the committee. Tanya Brown, TONJA-BROWN, advocates for the inmates and the innocent. I want to touch on agenda item 3, discussion for solicitation of recommendations for the committee. We have submitted our recommendation, and I have a letter I'd like to read. I am writing in support of posthumous exonerations. My name is Ray Crone, and I have a personal experience in support of my position. I was convicted of a murder and kidnapping in Phoenix, Arizona in 1992. 10 years later, DNA testing identified the true perpetrator, and I was released, and I am originally from Pennsylvania and was stationed in Arizona at Luke Air Force Base in 1980. After my honorable discharge, I later got a position with U.S. Postal as a letter carrier. I had worked there for 7 years at the time of my arrest and no criminal record. I refused to plea bargain. I was on trial for a trial in only 7 months. I was convicted in a 3-day trial based on a bite mark identification. I was sentenced to death. I was 35 years old. The majority of my family is all in Pennsylvania, a long way off, but they believed in my innocence and fully supported me for those long 10 years. This gave me the strength to survive a harrowing ordeal. I was found innocent and released. DNA saved my life. I know just how fortunate I am. The evidence was not only made available, but it was available before I was convicted. I can tell you the prosecution objected and fought us all the way to my release. They were wrong. But what if I had been executed? My family, friends, and even the legal team believed in me and fought constantly on my behalf. They were convinced of my innocence and would not give up against the full powers of the state of Arizona. Do you believe they would have quit their belief and their determination to prove my innocence after my execution? No. I can guarantee you that. How would you feel in their shoes? This is not a singular incident. Mistakes are made in our criminal legal system. I only ask that you recognize this as a definite possibility and allow for any unfortunate family in this horrific situation the opportunity to prove their loved one's innocence after death. I thank you for your time in the requested consideration. Thank you.
Thank you, Ms. Brown. Is there anyone else there in Carson City wishing to make public comment? Not seeing anyone. We will go ahead and broadcasting, please open the lines.
Thank you, Chair Miller. To provide public comment, please press *9 now in your phone or raise hand in your Zoom window to take your place in the queue. Caller, you're unmuted. Please proceed.
Yeah, can you hear me?
Yes, we can.
Hello?
Please
Yes, we can.
proceed.
Hi, my name is Julie Belshi. My foundation is National Guardianship Liberty Movement. When we recover loudly, we keep others in guardianship from dying quietly. It is all of our choices. My story is not a sad story. It's a real one. It's the story of a woman who fought through a storm she thought would never end. You are a product of your circumstances until you are aware that you are a product of your circumstances, then you can choose to become a product of your new awareness and your choices. I'm thankful to those that hear me today, that see me and accept me, the ones assigned to make this corrupt RICO involving the guardians and all cohorts go away and at the very least be held accountable. At some point in every lineage, a soul is born that refuses to conform, speaks the truth. I'm standing with you for change in the corrupt guardianships and all involved. You that stand against the corrupt guardianships and all involved can start to bring healing throughout for the protected persons and families. Stealing and killing the innocent wars is illegal. Taking our beloved family and friends and cutting off our family lineage is a sin, especially when there is family members to take loving and quality care of their families first. If you're listening to what I'm reading, you have the chances and are the souls to help us in stopping our courts from profiting and depleting our family members from losing their golden years, enjoying them being surrounded with family. My parents, Rudy and Rennie North, were illegally taken from their home in 2013. Please refer to How the Elderly Lose Their Rights by Rachel Aviv in The New Yorker. Please also watch The Guardians, directed by Billy Mintz, available on Amazon Prime or on YouTube. My parents, Rudy and Rennie North, were just 2 out of the millions that were abducted and thrown into corrupt guardianships by April Parks, who is serving 16 to 40 years, along with her husband, Gary Neal Taylor, and also Noelle Palmer Simpson, who is disbarred, former attorney that was disbarred. Where is the data? Where is the transparency? If there's nothing to hide, why is there no accurate records? Are we erasing people from our society? Is this domestic terrorism in our own homeland front? I have a new foundation, National Guardianship Liberty Movement, and we're looking forward to joining with you with several formed agencies to come up with concrete solutions. Can we spare one more precious life and family to go through the torment of being blindsided when their beloved relatives is abducted from their home with no communication to the family? Guardianship needs to be abolished. This can happen to anyone. I do know, as I've ran additional helplines for 8 years, every walk of
Ma'am,
life
can you
this can
please
happen
wrap up
to.
your
I've helped
comments?
staff.
Can you
Sure.
please wrap
Thank
up
you
your
so much.
Thank you. Thank you.
Yes, I
Anything
can. It
additional?
has a couple more sentences. I have helped pass legislation here in Nevada and across the United States of America, and I've worked with the government. I'm requesting that we work
Okay.
together. If you have any
Thank
questions,
you.
please
Please.
email me at National Guardianship Liberty Movement at AOL.com. We're in this together.
Okay,
and
thank you,
change
ma'am.
is
I'm
on
going to
its
ask
way.
that you
Thank
submit the
you,
rest
Julie
of your
Belsey.
comments in writing. All right, can we
Great.
go to the
Thank
next
you
caller,
very much.
please?
This is Julie Belsey. Thank you so much.
Thank you, Chair. Moving to the next caller. Caller with the last three digits, 631. Please proceed. You are unmuted.
Okay, can you hear me?
Yes, sir, we can hear you.
Okay, my name is Roger Hilligus. I'm calling from Reno, Nevada. I'm a little discouraged that I only have 2 minutes because that doesn't seem like you're taking the public serious. The public, you work as public servants for the public. You should give us more than 2 minutes of time to speak, because what I have to say is important and it comes from experience. You can Google my name and look me up on the internet and on YouTube. There's a lot that I have to talk about regarding guardianship. Guardianship should never be imposed. It's illegal to take somebody's rights and give it to another person without due process. And in the court system, it's happening every day where people's rights are being taken away without due process. You have to ask, what's the reason why they're taking these rights away of the elderly? And it's because there's federal Title IV money that the states get claiming that they're protecting the elderly from their family. They should reverse the situation and they should only get Title IV money for every guardianship that's not imposed, because guardianship should never be imposed when there's family willing to care for somebody. Rights are taken away only for people in criminal cases. So in guardianship, there must be a grand jury prior to any proceedings, because you cannot take somebody's rights away, give them to somebody else, and then lock them away in a facility and deny them their family. These changes must be made, because this is more than just guardianship, NRS 159. This involves NRS 433A, NRS 449, NRS 65, our Nevada Constitution, and the United States Constitution, and it also involves Supreme Court Rule 252, which is involving mediation. So once you get into civil courts with guardianship, you have a judge that wants to mediate, and that's illegal through Supreme Court rule. There's also a lot of conflict of interest in guardianship, because you have corporations like the Washoe Legal Service, you've got medical facilities, and you've got representation from bar members, and there's a lot of conflict of interest when that gets involved. So that needs to be looked at as well. Anybody that has advanced directives, those need to be followed, as the people are speaking for themselves through their advanced directives. There's never
Sir, I'm going to ask that you wrap up your
evaluations that could be
comments. We're
held.
over 2 minutes. Sir, I'm going to ask that you wrap up your comments. We're over 2 minutes. And also, please know that when you do submit your full comments in writing to us, that is sent directly to each legislator that's on that committee. So I don't want people to think that it goes into the abyss. It does come directly to us. So please wrap it up, because we're over time right now.
Okay, I've got just a last comment to make. I appreciate you giving me the time and allowing me to place something in writing. I know that there's a lot of the Senate and Assembly members that recognize my name, but the general public that's listening to this may not know, but I am Roger Hilligus, and I do speak from experience. And here's my last comment. The State Bar of Nevada is considered an enterprise and a syndicate. When members of the bar collude to impose a guardianship, that is the true definition of RICO, R-I-C-O, racketeering, influenced, corrupt organizations. Please consider, when these individuals are conspiring to impose a guardianship, that they are doing this illegally. So please follow the Constitution and people's rights. Guardianships are illegal. They should never be imposed
Okay, thank
when
you-
there's
thank
family
you so
willing
much,
to care
sir.
for somebody.
Thank you so much, sir.
Thank you.
Broadcasting next caller.
Thank you, Chair. Moving to the next caller.
Anne Marie Grant, for the record, ANNEMARIEGRANT. My brother Thomas Purdy was 38 years old when he had a mental health crisis and was hogtied by Reno police for 40 minutes and then asphyxiated to death at the torture chamber known as the Washoe County Jail. I'd like to reiterate the comments of the two previous callers in regards to guardianship. If you haven't heard of Roger Hilligus, please Google it. And I would like to comment on agenda item 12, body-worn cameras. I recently put in a public records request to the Washoe County Sheriff's Office requesting all body-worn camera footage with any tag or label in the Axon system to indicate that footage of his interactions with Roger Eugene Hilligus between 1/1/22 and 3/15/2024. Their response was, staff conducted a preliminary search and it is estimated that it will require at least 261 hours to complete this request. Pursuant to public records fee schedule, related requests may be aggregated for the purposes of determining the number of hours spent fulfilling them. Although generally the staff time fees are waived for the first 10 hours, this request is aggregated with previous similar requests and will therefore be subjected to charge. Staff time is charged at $24.33 an hour. The current estimate is $6,114.30. Additionally, the requester must provide payment for half of the estimate. Let me just say this. Is that normal for there to be 261 hours or however many hours of footage of an inmate? No, they had a plan and a motive, and they retaliated against Mr. Roger Hilligus because while he was incarcerated at the hellhole called the Washoe County Jail when my brother was murdered by deputies, he was a whistleblower and spoke out against the abuse, the medical neglect that's been going on. I've been telling you people about this for years. Stop turning a blind eye to the issues that are at hand in your state and take action. Thank you.
Thank you so much. Broadcasting, do we have another caller?
Once again, we are on public comment. If you would like to provide public comment, please press star 9 now to take your place in the queue. Caller, you're unmuted. Please proceed.
Hello, can you hear me?
Yes, we can.
Hi, my name is Karina Singer. I'm here to speak as well.
I'm sorry, could you repeat that?
I'm sorry, I didn't know if everybody could hear me or if they were just asking.
We can
My name
hear
is
you.
Karina Singer. Good morning. Thank you for the opportunity for public comment. Thank you, Roger, Julie, Anne-Marie, and other elderly victims and family members who are here fighting for freedom and justice against guardianship. Again, my name is Karina Singer, and today I'm speaking about our guardianship system. I have personal experience dealing with this topic when my sweet father was taken to court by my sister to secure an unnecessary guardianship without the necessary evidence to do so and without an attorney present. My father was locked up in a secured facility, over-medicated, and severely abused until his death. Since then, I have faced a grueling probate proceeding that has gone on for more than 4 years and has been wrought by legal malpractice and judicial misconduct. Today, however, I am honored to stand before you as a proud member of the National Guardianship Liberty Movement. This nonprofit organization founded by the indomitable Julie Belshie, who spoke here earlier, whose courageous journey to save her parents from the depths of a broken guardianship system was captured in the powerful documentary, The Guardians. We are united in our mission to drive change. Picture this: a beloved family member, vulnerable, in need of care, falls prey to a system meant to protect them, but instead subjects them to unimaginable abuse, isolation, and financial exploitation. This is the harsh reality faced by countless elderly individuals under the guardianship system. Families torn apart, life savings drained, and the basic right to freedom snatched away. But we refuse to accept this as the norm. We are the voices of the voiceless, the advocates for those who are vulnerable, and the champions of justice. The National Guardianship Liberty Movement is more than just a nonprofit organization. It's a beacon of hope for those ensnared in the clutches of guardianship tyranny. Through our wavering dedication, we offer support, resources, and legal assistance to those battling this injustice. But our work extends beyond legal battles. It's about restoring dignity, reuniting families, and reclaiming the rights unjustly taken away. Today, I implore you to stand with us in this noble cause. Let us confront corruption, challenge the status quo, and empower individuals to reclaim their freedom. Whether through volunteering your time, sharing your experience, or simply spreading awareness, every contribution matters. National Guardianship Liberty.
Ms. Singer, can you please wrap up your
AOL.com.
comments?
I'm sorry, I'm done. Thank you so much.
Thank you so much. Next
Chair,
caller?
there are no additional public comment callers at this time.
Okay, thank you for that. We will go ahead and close public comment. Again, we will have another public comment section at the end of today's meeting. With that, agenda item 3 is the discussion of solicitation for recommendations for the committee. So posted on the committee website is the committee's solicitation of recommendations. The committee invites all interested parties to provide recommendations in writing for possible consideration by the committee during its work session. And so for those that are new to the interim process, that's literally when we're evaluating which ideas that we would move forward as a committee for bill draft requests to become committee bills during the regular session. And that is open to, when we say all interested parties, that does include individuals as well. The committee is scheduled to hold this final meeting of the interim on August 30th. In advance of the meeting, committee staff will be reviewing meeting materials and testimonies received at meetings to develop a list of recommendations for review by the chair and possible consideration by the committee during the work session scheduled for this meeting. Written suggestions for recommendations along with appropriate background information and any other details you can include must be received by Wednesday, August 7th, 2024 at 5 p.m. I will repeat this. The last moment to submit recommendations for consideration for this work session is Wednesday, August 7th at 5 p.m., no exceptions. So please understand the work that the committee and members have to do, and so there's a reason why we need deadlines in place. So with that, we will move on to our next agenda item, which is agenda item 4, the discussion of and recommendations regarding potential prison industry programs. If you recall, there was a discussion back on February 23rd for this, and so the recommendations have been made. This is by Deputy Director Cuenga, and I believe, yes, you're already at the table in Carson City. He is the Deputy Director and Acting Public Information Officer for Silver State Industries of Nevada's Department of Corrections. Committee members, this committee is required to review any proposed industrial programs for compliance with the requirements of subsections 2, 3, 4, and 7 of NRS 209.461. So again, this is going back to that February 23rd meeting with the proposal. At the end of Mr. Cuenga's presentation, we will vote on whether to recommend the approval of the proposed industries. Now, so everyone understands the process, once we approve these, they will ultimately still have to be approved by the Board of Examiners and the Prison Commission, according to NRS 209.459. So with that, Mr. Cuenga, please proceed with your two proposals.
Good morning, Madam Chair and members of the committee. Thank you for your time today. I have before you a request for approval to move forward on negotiations for a contract with two new potential business partners. The first business is Substantial Reform Solutions, which I've sent in a attachment. Substantial Reform Solutions is a ink remanufacturing program. The purpose is to make positive change to the communities which it operates. They have work training programs to help offenders learn effective job skills. They work with institutions to create environmentally friendly ink and toner cartridges and prepare offenders for future reentry success. Since 2006, SRS, Substantial Reform Solutions, has operated operated prison programs in various U.S. states, the UK, and Spain. Its current flagship operation is with the Virginia Department of Corrections, where since 2015, SRS have built and shipped hundreds of thousands of printer cartridges and employed over 250 offenders. The scope of work is sustainable reform solutions, collect empty printer cartridges from qualified customers. These are remanufactured in a prison and sold back to qualified customers. The income generated is used to fund the offender labor and provide cash flow to the industry. This also affords an opportunity for our population with the Department of Corrections and Silver State Industries to offer employment at our women's facility down at Florence McClure Correctional Center. At this point, we do not have any industries for our female population. I've been working hard to try to get something in there. And I'm open to any questions on the first proposal.
Okay, so then we'll go ahead. Members, do we have any questions for this first proposal? Okay, Vice Chair Scheibel.
Thank you so much for your presentation, and I think I understand what the company would do, and I'm just wondering if Silver State Industries would need any kind of additional machinery, supplies, infrastructure in order to be able to accept this contract?
For the record, Bill Quenga, Deputy Director, Department of Corrections. No, ma'am. The SRS will be providing all the training and all the equipment to our offender employment. We have space at women's facility right now.
Okay, thank you.
Members, any additional questions? Okay, not seeing any. Please move on to your second proposal.
For the record, Bill Quigg, Deputy Director, Department of Corrections. The second business is Carson Trust, LLC. Carson Trust, situated on 5 acres just outside of Carson City in Mound House, is a manufacturer of engineered wooden trusses established in 2022 to help fulfill the growing housing demand. The trusses are sold to framers who install them into the roofs and floors of both single and multi-family construction projects. The company has a single shift workforce of about 20 full-time employees and would like to add a second manufacturing shift, but have faced significant challenges in finding and retaining reliable labor. A former staff had success in working with the Nevada Department of Corrections for High Desert Trust staffing needs. Based on the demand from customers, Carson Trust would be able to hire 9 to 13 offenders immediately to launch a second shift and potentially more in the future. Scope of work of this partnership is great opportunity for Carson Trust to gain access to reliable source of labor and scale operations, while at the same time helping offenders develop real-world skill that will benefit them upon their release. Ideally, as offenders are released from custody, they would continue their employment with Carson Trust. The roles of the facility include sawyers, truss assemblers, forklift operators, Class A CDL drivers, and materials handler. Positions also include an office staff of an administrative assistant, production manager, truss designer, and site general manager. I'm open to any questions on this second proposal.
Thank you for that. Members, do we have any questions? Not seeing any. Thank you for your two proposals. With that, I will entertain a motion to approve both new proposed programs as recommended by NDOC, which will ultimately be approved by the Board of Examiners and the Prison Commission. So with that, do I have a motion?
So moved.
I have a motion by Vice Chair Scheibel. Do I have a second?
Second.
I'm sorry, I didn't catch where that second was from. Was that you, Assemblywoman Gonzalez?
Yeah.
Okay, we can't see you, but Senator Harris has a very good ear. So with that, I'll take a second from Assemblywoman Gonzalez. Members, any discussion? Okay, with that, all those in favor, please say aye. Aye.
Aye.
Aye. Is there anyone opposed? Okay, not hearing or seeing anyone opposed. Then with that, the motion carries. Thank you so much.
Madam Chair, thank you, and committee members.
You're welcome. Thank you. With that, we will move on to our next agenda item, which is agenda item 5. It's the presentation by the William Boyd School of Law, from University of Nevada, Las Vegas on the school's work with communities in Nevada and outcomes with workforce development. There will be a PowerPoint to also that Professor Grinvald will be using. She is the Dean and Professor of Law at Boyd School of Law. And with that, just as we get into our presentation section, I want to remind everyone that everyone has been asked to keep their presentations concise and to 15 minutes because we obviously have a robust agenda and lots of questions. And so just do know if we start going over that 15 minutes, I will ask folks to wrap it up. So with that, when you're ready, please proceed.
For the record, Leah Chan Greenwald, Dean, and Richard J. Morgan, Professor of Law at the William S. Boyd School of Law at UNLV. Good morning, Chair Miller, Vice Chair Scheibel, and committee members. Thank you very much for allowing me this opportunity to present you with updates on the law school's work with Nevada's communities and about our work in preparing students to meet the needs of Nevada. It's hard to believe, but the William S. Boyd School of Law at UNLV is celebrating 25 years of transforming Nevada. We first opened our doors in August 1998 at the Paradise Elementary School. And in our short 25 years, we have zoomed up the national rankings. We've been a top legal writing program for the last 10 years and have been number 2 for the last 2 years. Our dispute resolution program is ranked number 7, and our part-time program, thank you, and our part-time program is ranked number 13 in the country. We've been rated a best value law school. In addition, not pictured here is that we are ranked number 42 of all public law schools in the United States, and there are 86 of them. At the law school, we offer 2 professional degrees, the Juris Doctorate and the Master of Laws. This past academic year, we had a total of 459 students, which comprised of 445 JD students and 14 LLM students. Of this class, 88% were Nevada residents, with 12% as non-residents. Our student body is diverse, with 51% female, 40.3% students of color, and 20% identifying as LGBTQ+. The JD is a pathway to professional success. Through a rigorous three-year full-time or 4-year part-time program for the JD degree, we train our students with the skills to provide the services that drive Nevada's economic engine. We have done this fairly successfully, as you can see, for the last 25 years, but the data here shows you the last 13 years. For example, last year's graduating class of 2023, had an employment rate of 93%. Although not all of our graduates pursue a legal practice, another hallmark of our success and in developing our graduates to assist in the economic growth for the state is passing the state's bar exam. This graph shows the first-time bar passage rate of Boyd Law students in Nevada for the last 13 years. Not pictured here is that although approximately 25% of students did not pass on the first try in the last couple of years, within 2 years, that number is well below 5%. Since joining Boyd Law, I have made it a priority to dig into what we can do to help those 25% pass the bar exam on the first time. A major cause for them not passing on that first time is that they need to work while studying. If we were able to scholarship them during the summer while studying and they could focus full-time on their studies, the pass rate would likely be much higher. And I'll come back to this in a minute. As the only law school in Nevada, we take great pride in being Nevada's law school. We have a statewide mission to serve Nevada and produce professionals who are going to be those drivers in the communities for economic growth, whether be it as leaders, entrepreneurs, managers, or employees. And we have a number of programs and activities that do this. We support various clinics through our Thomas and Mack Legal Clinic that provide students with an education in serving clients, the very work we hope they'll do after graduation. For example, we started a new tenants' rights clinic this past year in partnership with the Legal Aid Center of Southern Nevada to represent tenants in housing court. Students were taught how to represent clients by doing work under the supervision of licensed attorneys. Students in the clinic take an attorney's oath and have the same ethical responsibilities to their clients as lawyers do. In this way, we help the community twofold. Our student attorneys provide free legal help to their clients, and they're also trained to do this work in the future, either as public interest attorneys or giving back through pro bono assistance. We also have the Immigration Clinic that provides deportation defense services for free, as well as represents students and faculty at UNLV with their immigration issues. In addition, our Thomas and Mack Legal Clinic houses the Poverty Law and Policy Clinic, the Mediation Clinic, the Survivors Representation Clinic, and new this coming fall, the Economic Justice and Small Business Clinic, which will start to represent small businesses with their legal needs. Second, we partner with legislators in helping with their policy work to solve Nevada's challenges. For example, our faculty and students were deeply involved with Senator Neal's work on Windsor Park. First, with research many years ago about the environmental impact, then with putting together the award-winning documentary, and then with the landmark legislation that was passed last session to provide residents with new homes. We've also been working to incentivize students to extern or intern in rural counties and have been successful in sending students each summer to a rural county to work there. This provides free critical support to those offices, such as the Public Defender's Office, as well as introduces students to the potential career path for them in rural counties, which desperately need more lawyers. In fact, our externs provide over $1 million each year in free legal help. In addition, we are involved with K-12 outreach, which also helps with Nevada's workforce development, in that we plant an early seed that law school is a possibility for all. Our community engagement activities run from visiting elementary schools such as Robert Lunt and Roger Bryan Elementary Schools during Reading Week, judging and supporting and coaching We the People, as well as providing field trip and internship opportunities to high school students from schools such as Canyon Springs and Veterans Tribute. To continue to do all this great work and to even expand upon it, I wanted to preview the law school's request in the upcoming session. We are asking for enhancements to the base budget. $1 million for the Thomas and Mack Legal Clinic in each year of the biennium. This would allow us to hire additional faculty to teach in the clinic, as well as to provide stable support for the clinic needs. In addition, we are asking for $1 million in each year of the biennium for student success initiatives. This would allow us to scholarship our students as they prepare to take the bar exam. This way, they wouldn't need to work as much as they do now while studying, and will help to get our first-time taker percentages, pass percentages, over 90%. Finally, I wanted to let you all know that we are here at the law school to help you as you prepare for the 83rd session. Please feel free to reach out to me if you need any help with research, policy issues, or white papers, and anything else you might think about. I also brought a handout. It's on the side table that has a little bit more about all of the data that I presented fairly quickly to you. But thank you again. It's been a pleasure. And here's my email address, and please feel free to be in touch. I would be happy to answer any questions.
Thank you for your presentation. Members, do we have any questions? Not seeing any questions. I do have one question. How many students that attend Boyd are actually Nevadans? Like, how many come through from Nevada as opposed to out of state?
That's a really good question. I only know percentages, not specific numbers. Just to give you an example, each year we bring on 130, ish new 1L students, and of that, 75% are Nevadans. They eventually become Nevadans, and even if they came from out of state, they stay here and work here. We have about a 95% rate of capture, if you will, of being the brain magnet to the great state of Nevada. But I think the first year class, because most of them become residents after that first year class, at 75% is the best number to give you an idea of how many are truly Nevadans.
Okay, great. Thank you. All right, well, not seeing any other questions, I will go ahead and close this agenda item and open up our next agenda item. So agenda item 6 is a presentation by the Statistical Transparency of Policing, or STOP, Statistical Transparency of Policing Project. Again, there will be a PowerPoint to accompany this. We have Dr. Cools, who is the Associate Dean for Research and Professor and Chief of Acute Care Surgery Division of the Kerkorian School of Medicine at UNLV, and also Dr. Tango from the Traffic Safety Research who is the Traffic Safety Research Project Manager, Department of Surgery, also from the School of Medicine at UNLV. And so I will let you introduce the third person that is present, and also once you have your PowerPoint ready, you may proceed.
Yes, good morning, Chair Miller, Vice Chair Scheibel, and distinguished members of the Joint Interim Standing Committee on Judiciary. Thank you for giving us the privilege of presenting our first annual report on statistical transparency of policing, hereinafter referred to as STOP, as it relates to law enforcement traffic stops in Nevada. I'm Deborah Cools, Associate Dean for Research at the Kirk Kerkorian School of Medicine at UNLV and Principal Investigator of the Nevada Office of Traffic Safety funded STOP project. Several co-principal investigators and co-investigators are here either in person or on live stream today, including Dr. William Souza to my right, who is from the Department of Criminal Justice at UNLV. I would like to introduce you to Dr. Bertil Mavangam to my left. She is the director of our STOP project. She will briefly present highlights from our first annual report. Following Dr. Mavangam's presentation, we'd be happy to answer questions. Thank you.
Thank you, Dr. Mavagam. For the record, I'll be presenting an overview of the Statistical Transparency of Policing, STOP, Nevada Data Collection Project. This project is funded by the Nevada Office of Traffic Safety, and the source of annual funding is the federal 1906 funds, which states apply for every year. The goal of the STOP project is to develop and implement a statistical transparency of policing program in the state of Nevada that aligns with Senate Bill 236 regarding traffic-related stops. Let's talk a little more about Senate Bill 236. Passed in 2022, SB 236 requires law enforcement officers to record and report traffic stop data for all traffic stops that result in citation issued to the electronic citation system starting in 2022 and ending in 2025, and for a traffic stop for which they issue a written citation or warning starting in 2024 and ending in 2025. As it stands now, SB 236 data collection ends in 2025. SB 236 also requires law enforcement agencies that receive traffic stop information to report such information to the Nevada Department of Public Safety, hereafter DPS, and it also requires DPS to develop a standardized method to record traffic stop information in an electronic traffic citation system, and allows DPS to contract with a third party to analyze traffic stop data for the purpose of identifying patterns or practices of profiling. SB 236 requires such third party to report regularly the results of the analysis to the governor, the department, and the chair of the Senate and Assembly Standing Committee on Judiciary. SB 236 implementation includes data collection, data analysis, and reporting of results. In terms of data collection, OTS oversees SB 236 data collection, and Tyler Technology is the citation system administrator. In response to SB 236, OTS requested modification to the existing traffic citation software that is used in Nevada by law enforcement statewide to capture citation to collect additional SB 236 traffic stop data. In terms of data analysis, UNLV STOP team received grants from OTS as a third party to analyze the data. We are a multidisciplinary team. In terms of reporting results, we conducted a descriptive analysis of traffic stop data collected in Nevada between January and December 2022, which is the first full year of SB 236 data collection. We generated the first report, which is descriptive in nature, and we'll talk a little bit more about the descriptive report. And we delivered this report to designated officials per SB 236. We collected best practices from other states that have experience in analyzing traffic stop, including Connecticut, Oregon, and California, and best practice recommends a multi-year data set in order to conduct comprehensive data analysis to identify potential disparities in traffic enforcement. It is important to note that the Council of State Governments and the University of Connecticut have received grants from Arnold Venture to provide technical assistance to several states in conducting traffic stop analysis, and Nevada was chosen as one of the states that will be receiving technical assistance. Let's focus our attention to our first report the 2022 descriptive report. And we have copies of this report on the table on the left. The goal of this report was to provide a descriptive analysis of Nevada traffic stop data, 2022 traffic stop data. We examined data collected through the citation system administered by Tyler Technology and available to the stop team. It is very important to note that limitations to the data prohibit conclusion or inferences about disparities in traffic stops. This table shows the data element as specified by SB 236 and available to our team. We'll talk a little more about it in the next slides. And the next table shows the data collected per SB 236, but limited, meaning incomplete, not consistent with SB 236, or not available to our team. We'll talk a little more about this in our limitation section. As methodology, we received data, monthly data from OTS. We received 271,765 traffic stop records from 41 law enforcement agencies in Nevada, and the data underwent rigorous validation protocols. We cleaned the data, we structured the data, and then we conducted descriptive analysis using frequencies and bar and line graphs to visualize the data. Our findings, starting with reported outcomes, most traffic stops resulted in citation. It is important to note that in 2022, warnings were not required to be reported per SB 236. It's required starting 2024. This may explain why most traffic stops resulted in citation. In terms of officer perceived risk of the driver, most drivers were white. In terms of officer perceived ethnicity of the driver, most drivers were not Hispanic. In terms of sex of the driver, which was taken from the driver license, more than 62% of drivers were male. In terms of age of the driver, taken from the driver license, more than 50% of drivers were between the ages of 21 and 40 years. In terms of agencies, most traffic stops were reported by Nevada Highway Patrol, followed by Las Vegas Metropolitan Police Department. Let's talk about our limitations and some considerations. As I previously said, we were not able to assess potential disparities in traffic enforcement, due to limitations in the depth, the breadth, and the completeness of the data. It is important to note that multi-year and complete data set is recommended to fully assess potential disparities in traffic stops. This table shows limitation of data that we receive, starting with age and sex. This was taken from the driver license, which is different from the language specified in SB 236. This may confound analysis to identify potential disparities in stops based on perceived age and sex. The nature of and statutory citation for the alleged violation that caused the stop to be made is currently not being collected in Nevada and therefore not available to our team. Therefore, we were not able to examine this data in this report, and we could not assess any disparities in reason for the stop. However, DPS and OTS and Tyler Technology are considering collecting this element in the future, and the rollout date is still to be determined. Data on warnings reported through the electronic citation system may not be completed. As I previously said, reporting for warnings was not required per SB 236 in 2022, the first full year of data. This limits our ability to identify potential disparities in stops that resulted in warning. It is important to require consistent collection of data about warning and consider correcting whether a warning was issued, yes or no, and if yes, what type of warning was issued, verbal or written, in order for us to be able to conduct analysis to look at disparities in terms of warnings. It is important to note that data on citations and warnings are collected through the electronic citation system, and data on arrest are collected through specific law enforcement agencies' systems, which are different from the citation system. The lack of integration between the citation system and the specific law enforcement data collection systems cause the data on arrest to be incomplete. The data on searches were also incomplete because many searches are linked to arrest. This limited our ability to identify any potential disparities in arrest, searches, and the results of the searches. It is important to explore possibilities of linkage between citation systems and other systems that contain search and data and arrest data. It is also important to consider adding whether an arrest was made, yes or no, and whether a contraband was found, yes or no, in order for us to be able to look at potential disparities in outcomes of the search. In summary, in terms of data collection, it is important again to note that SB 236, as it stands now, the data collection only goes through 2025. A legislative initiative is required in the next legislative session in order for SB 236 data collection to continue past 2025. It is also important to add the reason for the stop to the data collection system and explore possibilities of linkages between citation system and other systems that contain search and arrest data. In terms of funding, continuous and adequate funding is necessary in order to continue SB 236 data collection and data analysis. The STOP project is currently funded through federal 1906 funds, which states apply for each year, and the amount depends on the number of states that apply. So it is important to look for other sources of funding in addition to 1906 funding in order for this project to continue. Our future goal is to conduct advanced statistical analysis of 2 years data, the 2 years that we have, the 2022 and the 2023 data, and to report findings as required by SB 236. But we also plan to generate a better version of a traffic stop data dashboard. With a dashboard, it allows users to access the data and visualize the data, increasing transparency in policing. This is the end of our presentation, and thank you for your time, and we are happy to take any question.
Thank you so much for that. Members, are there any questions? We'll start with Vice Chair Scheibel.
Thank you so much for this presentation, and I'm perusing also the what looks like a longer report that you've provided us, and I so appreciate all of the hard work that you've put into it. You said something at the beginning, I'm trying to go back and find it, but you indicated that we couldn't make inferences about disparities in traffic stops, and I was hoping that you could just explain that again for us to make sure we have a clear understanding of what you're saying.
Thank you, Dr. Mavagam Tango, for the record. So the data that we receive had some limitations, which did not allow us to conduct advanced statistical analysis. In addition to that, best practices collected from other states requires at least 2 years of data to be able to conduct advanced statistical analysis. And we only had 1 year of data, which is the full, complete 2022 data that we had. But in the future, we plan to conduct advanced statistical analysis, but this is contingent upon having more variables, more years of data, and complete data sets.
Okay, that makes perfect sense to me. And so I think what you're saying is that in order to have a data set that we can make those inferences from, we not only need another year of data, but we also need to improve the data that we're collecting by adding, I think you said, more variables. And what else do we need to put in the bill? That's what I'm trying to ask you.
Dr. Cools. Thank you. Deborah Cools for the record. Also, there are in the report a list of additional variables. It would also be helpful to have the data linkages to the other systems that Dr. Mavagam referred to. They're also, in the report. We also are working with agencies and the third-party vendor to make sure that we actually have data for all the data elements. There were some missing data elements.
I have a follow-up question on that because I'm guessing, I think you mentioned that one of them was either Tyler or Brazos that you're collecting data from. Do those companies operate in other states that collect data in a similar way and where they are able to draw analyses? So I see you nodding. So am I correct in assuming that we are already contracted with companies who are capable of doing this? It's just a matter of doing it in Nevada.
Dr. Mavagam, for the record, yes, they collect data in other states. One thing that I want to point out here is the lack of integration between the two systems for citation and arrest data. And this limits our ability to look at disparities in outcome of the stops, meaning a person is pulled over, yes, what is the result? Is it a citation? Is it an arrest? If we don't have a complete data set on arrest, we will not be able to analyze that data.
If I could also add, this is Deborah Cools for the record, also on warnings that we mentioned are not consistently recorded.
And if I may add one last thing, I'm sorry. So for warnings, it started this year. And as it stands now, SB 236 data collection ends in 2025, which means we'll only have 2 years. So it is also important to emphasize that in order for SB 236 data collection to continue, there is a legislative initiative that is needed. Thank you.
Deborah Cools for the record. I think one additional, consideration is we should have 2 years worth of data, obviously coming up very shortly. But in talking with multiple states, they require their best results are with multiple years. So 2 years, we're hopeful that we can move the ball forward, but in reality, and talking to the other states that have been doing this longer than we have, basically the more data you have, the better conclusions you can reach. So it's important to have more than 2 years data as well.
Thank you for that. Senator Harris?
Thank you, Chair. I just wanted to take this opportunity to thank you all for what you've done with the legislation that I passed. It's not often that you pass legislation and your expectations are exceeded in how it's been implemented and the dedication of the work that the people put behind what you were trying to do. So I wanted to take this opportunity to publicly thank you all for doing more than I could have even imagined you would have done with this legislation. And I really do appreciate your commitment to not just bringing the sheer text of the bill to life, but the real meaning behind it, which is true statistical analysis in order to drive good public policy. So thank you.
You are most welcome. And I think, I would really like to give a shout out to our team that's very multidisciplinary. So not everyone could be here today. So we have experts on, criminal justice, as in Dr. Sousa to my right, disparities, high-level statisticians, and so forth. So without that, I think, without that team, we would have much different results and future plans. So thank you for your support. Thank you. Okay.
Members, are there any additional questions? Okay, I have a few questions. I just want to go back to the discussion that with Vice Chair Scheibel, just to get a little more into the details about it, specifically when it comes to the options for race and ethnicity. And so you shared that there was the option for white, and this was by officer, just kind of perception, white, non-Hispanic, and then black. And so we know that there's a variety of people that don't fit into any of that category, especially visually. I know I've been visually misidentified daily for my life, and many people are. And I passed a bill last session about getting Middle Eastern North African as a category on here because of these types of issues. And as I'm sure you all know, the federal government just recently announced that starting with the 2030 census, the MENA question will be an option on the census to better identify people. So I was just wondering if you could just go through again what are the categories that are available to an officer to kind of identify or categorize so that we get a better picture, because we know there are a lot of people that specifically in that Middle Eastern North African category that are targeted, that are discriminated against, that are vulnerable, and yet we're not getting that data to see those discrepancies. So could you share exactly what is being calculated right now?
Thank you, Dr. Mavagam, again for the record. So on the screen, these are the categories in terms of race that are available in the data that we receive. So we have white, black, African American, Asian, American Indian, Native Alaskan, Hawaiian, Pacific Islander. And then in terms of ethnicity, it's not Hispanic and Hispanic.
Thank you. And so for an officer just making a visual, so they're just assuming, because again, we also have, specifically here in Nevada, many individuals who are biracial or multiracial, and so, which also may not be reflected on the shade or the color of their skin, if that's just what we're looking at. So were these categories based on what was in the bill, or are these categories, because I know that's currently what law enforcement is collecting. Can you just share a little more about that? Sure. Because of course we also know the discrepancy. There is because if we say this is the largest category of people pulled over, but then it would be interesting to compare that to individuals that then, you know, were in jail and going to, for those traffic violations as well at the time.
Thank you, Dr. Mavagam, again for the record. In the bill, I do not see like specific races, but I know this is what the officers have available. So I don't know if that answers your question.
It does, yes.
Okay.
It does, okay. Yes, it definitely does. With that being said, also, because I'm really interested about the warnings, and I understand that we don't have, that as scientists, you don't have the 2 years to actually, with the data, but there is like 5 months. So I was just wondering, have you had a chance to look at it, or have you been busy preparing, disseminating this information, or if there's any trend that we see already in the 5 months, if you're able or willing to professionally speak on that at all at this point?
Unfortunately, we are not able to comment on that yet.
Are you sure? Okay.
William Souza for the record. The likelihood is that the warnings here are really limited in terms of what's being reported in the system currently. And based on just past research, warnings are far more likely over citations and certainly arrests. And so, whereas we have so few warnings here within the system at the moment, we just were concerned about running any analyses related to it at this point. They would be just too limited.
Absolutely, thank you. One last question, and I'm not sure if I missed it. Do we have the reason the stops were made? That was one of the other challenges, right? That we don't know if someone stopped for speeding or running a red light or a broken taillight. We do not know.
No, this is currently not being collected in Nevada, and this is Dr. Mavagam for the record. The reason for the stop is not currently being collected in Nevada, but we do have the reason for the citation.
Okay.
Attached to the citation, which is different from the reason for the stop. But we had meetings with OTS and Tidal Technology about this, and they're considering adding that to the collection system.
Do you need a legislative act to do that, or is that just we do need a legislative act to do that?
This is Deborah Coles for the record. I think it would be very helpful if there was a legislative action. The other thing is, I think in this, it can be challenging to sometimes determine someone's sex by appearance, and right now that what's being collected is off the driver's license, so it is not perceived. So that would be another area for consideration.
Thank you for that.
And I believe in the report we elaborate on some of these points. Mm-hmm. If you would like us to provide another synopsis, we'd be happy to do that.
Thank you. I think next steps from this, what usually happens is as we're taking notes, because again, we talked about consideration for solicitation of bills, and sometimes it's not even people directly coming to us. Sometimes we're hearing those areas that need to be adjusted. And so with that, if we have additional questions, we'll reach out to you just to make sure that we have some, the detail points and have accurate information on those ideas for improvement. Not seeing any additional questions. Thank you so much for your presentation. Thank you. With that, I'll go ahead and close agenda item 6 and move on to agenda item 7, which is the presentation by the Peace Officers Standard and Training Commission, as we refer to as POST, including updates on the implementation of legislation enacted during the 2021 and 2023 legislative sessions. We have Executive Director Michael Sherlock with us. He is virtual, and just so no, that's the old one, right? We do not have a, it's my understanding we do not have a PowerPoint or any materials? Okay, so there's nothing, so that's just old from the last presentation. So, Executive Director Sherlock, whenever you're ready, please proceed.
Madam Chair, thank you very much. For the record, Mike Sherlock, I'm the Executive Director of the Commission on Peace Officers Standard and Training. Thank you for having me and allowing me to provide an update on recent legislation related to the Commission on Peace Officer Standards and Training. I'll try to be short and to the point. Let's start with the 2021 session. I was asked first about Senate Bill 212, which was legislation focused on peace officer use of force and also use of force policy. Although this bill did not address regulation or post directly, it did result in changes to curriculum, both in basic training for peace officers and related continuing education. Most of SB 212 had already been updated as we continually update our statewide training curriculum for basic training. Also, in addition, the legislature had previously made changes to continuing training that were consistent with SB 212. We reviewed curriculum to ensure things like de-escalation and, of course, the longstanding concept of objective reasonableness in the use of force are part of basic training. Curriculum has been updated in a variety of areas on subjects dealing with suicidal subjects, behavioral health crisis intervention, and the use of deadly force. Things like crowd control, demonstration and protest response are really at the agency level, but some of those components found in SB 212 in terms of training in this area are well settled and are included in curriculum in that area. The next bill from 2021 was Assembly Bill 336. This has been a bit of a challenge for us. That said, NAC 289 was amended by adding a new section regarding an annual behavioral health wellness visit for all peace officers in the state of Nevada. Our goal is to meet the intent of this legislation while not undermining or prohibiting some well-developed programs that our agencies were already implementing or employing, but at the same time keep posts out of any litigation related to sort of arbitrary mandates. After numerous workshops, public comment hearings, and working with several drafts with LCB, this regulation was approved and adopted per the language of AB 336. Moving to the 2023 session, Senate Bill 225 was a large piece of legislation related to peace officer standards and training. Let me just run through some of those changes we have made both in policy and in regulation to fully implement SB 225. First, all agencies now must include a signed affirmation for post-certificate applicants. If that application does not contain this affirmation, it is rejected. The affirmation states, one, that the applicant is not disqualified from serving as a peace officer under 289. Two, that the applicant has not been discharged, disciplined, or asked to resign for specific conduct. And three, has not resigned during an investigation. In addition, this bill requires posts to query the National Decertification Index for any applicant. Post has done this and of course will continue. Nevada Post was on the ground floor with the National Decertification Index and has a long-standing policy of checking NDI upon notice of hire and also application for certification. Further, Post regulations now require agencies to query NDI during the background process. In addition, Post enters into NDI those terminated for specific conduct, resulting in revocation under the requirements of NDI. This bill requires agencies to notice posts where a certified officer resigns during an investigation. Post has created a personnel action form in which agencies now report this activity to Post. This bill clarifies and makes changes regarding the use of marijuana and how it applies to disqualification or doesn't apply to disqualification during background. Our regulations are now consistent with this mandate. In addition, Post made changes to actual criminal cases related to marijuana usage, basically where the marijuana conviction is a conviction that would not be a crime today. It is no longer a disqualifier nor a revocation issue in the hiring and certification process. This bill makes policy and regulation changes regarding convictions for felonies and domestic violence, even where those convictions have been sealed. Post regulations were updated to reflect federal definitions of domestic violence convictions. And in addition, policy updates include the prohibition of hiring someone who is revoked in another state as a peace officer here in Nevada. These provisions, frankly, help us to clean up some loopholes and to ensure those who should not be in policing do not bounce from one state to another to work as a peace officer. We are quite thankful to Senator Harrison for working with us on this particular bill, and I think it will go a long way to improving policing here in Nevada. Finally, based on Senate Bill 323, NAC 289.200 was amended to allow the hiring of reciprocity applicants in the Category 3 arena. These are detention or prison working positions, which previously were not eligible for reciprocity, which means coming from out of state where they worked in this area of law enforcement in that other state. NAC 289-200 was amended to allow for Category 3 reciprocity in the hopes of improving recruitment here in Nevada. We believe it is having the desired effect. Those are the four major bills that directly affected Post, and we were asked to report back on, and I can answer any questions the committee may have on those.
Thank you for that. Members, do we have any questions? No questions? So one brief question. I just want to clarify. So we are now, so a marijuana conviction does not automatically eliminate someone from consideration, but a domestic violence conviction does. Is that correct? Even if it's sealed. And any other violent ones?
Yes, Mike Schrock for the record. So the specific changes were, yes, to remove marijuana convictions that would not be a conviction today as a disqualifier, and include domestic violence, which was already part of our regulations, but include those that have been sealed. Because the convictions has occurred, whether it's sealed or not, and we can still use that in terms of the background.
Okay, thank you for that. Members, any additional questions? All right, not seeing any. Thank you for your presentation. I will go ahead and close agenda item 7. Our next two agenda items 8 and 9, those will be taken together. So that will be Ms. Powers and Mr. McCormick. If you would like to approach. Agenda item 8 is a presentation from Nevada's Department of Sentencing Policy, including updates on the implementation of legislation enacted during the 2023 legislative and legislative priorities for the 2025 legislative session. Agenda item 9 is the update from the Nevada Sentencing Commission Subcommittee on Misdemeanors on the Comprehensive Review of Misdemeanor Offenses in Nevada. So I believe Mr. McCormick is in Carson City. Are you, oh, I see hands, I don't see faces. So I believe are you both at the table now? We're getting a different camera view. I see 2 hands now. So with that, you may, and we're seeing the back of your hands, just so you know as well. So with that, when you are ready, please proceed.
Thank you, Chair. Good morning, committee. Are you seeing the PowerPoint?
Not yet. Oh, now we are, yes. But now we don't see you. Okay. So we're going to need some assistance with that if we can just wait a moment. So we're not going to see it. Okay, so I guess we're going to see the PowerPoint right now, and then when you're back at some point, hopefully we'll see you. So just please proceed.
Wonderful. Good morning, Chair, Committee. My name is Georgia Powers, and I'm the Executive Director of the Nevada Department of Sentencing Policy. Today, I will cover the highlights regarding what the Nevada Department of Sentencing Policy does, the data and reporting highlights since last session, some of the Nevada Department of Corrections data and trends that we follow, and what the Nevada Department of Sentencing Policy is planning for the future. All right. Nevada Department of Sentencing Policy was created in 2019 to assist in making data-driven recommendations. We assist the Nevada Sentencing Commission with research and criminal justice data to make recommendations regarding sentencing laws in Nevada. Under the commission is the Nevada Local Justice Reinvestment Coordinating Council, which identifies programming and treatment needs at the county level to recommend reinvestment of funds to reduce recidivism. And lastly, the newly created misdemeanor subcommittee to study lower level offenses, which you will hear about in a moment. The department's mission is to promote an equitable and reliable criminal justice system by providing reliable criminal justice data, practical fiscal analysis, and comprehensive policy resources to lawmakers, stakeholders, and the public to ensure Nevada's sentencing and corrections policies and the Nevada criminal justice system as a whole are effective, data-driven, and resource-sensitive. Here you see our core values. We strive to have practical, meaningful, sustainable, unbiased and nonpartisan, collaborative, and Nevada-focused data available to the legislature, the commission, Nevada criminal justice stakeholders, and the public in order to make truly data-driven decisions about future laws. Next, we will discuss some changes and mandates brought about during the 2023 legislative session.
Thank you. For the record, John McCormick. I'm the Assistant Court Administrator at the Nevada Supreme Court's AOC, and I'm appearing today in my capacity as a member of the Sentencing Commission and the appointed chair of the Misdemeanor Subcommittee. The Misdemeanor Subcommittee's charge in Senate Bill 103 was fairly broad, and so we have sort of slowly gotten started on that. We've had a couple meetings. Currently, what we're doing is we're breaking the full committee down into groups to do a thorough review of the list of misdemeanors that LCB so graciously put together, the 85-pager, and asking those groups to identify misdemeanors on which they would specifically like to see data, and then misdemeanors that they believe should be repealed at this juncture, and then also what criteria the various sort of disciplinary subgroups would like to use to consider misdemeanors going forward, i.e. are there issues with disparate enforcement, penalties, all those kind of things. And those subgroups that I mentioned are, as I indicated, are based on sort of the disciplinary areas. We have obviously a judicial, prosecutorial, and law enforcement, public defenders, advocacy agencies. So this is a big task, and it has been a challenge, I think, to figure out how to get started for the group, but now I believe we've kind of come up with a way to move forward, and we're going to skip we have been meeting monthly. We're going to skip our June meeting to give those subgroups the time to engage in that sort of homework assignment we've asked them to do, and then report back in July to come up with sort of a path forward. It is my sincere hope that as the various disciplines identify their concerns and data needs, that hopefully we will find out we're closer together on a lot of this than perhaps we think. And again, it's a big subcommittee, probably larger than generally one would think on a subcommittee, but to me it was very important to get representation from all the sectors of the system that touch this.
And we'll move back to the PowerPoint. All right. So, Assembly Bill 388 from last session appropriated $3 million to fund county-level grants related to reducing recidivism. As you see here, it's targeting all 17 counties. We have received applications from 9 of those counties. The amount requested so far is approximately $2.3 million. We have approved $233,292 to grant out. There is another $588,422 currently in the review committee process. And there are 2 more rounds for accepting these applications, which close on June 7th and June 21st. As far as changes that came about from parole and probation to temporary revocations from Assembly Bill 32 last session, the law was changed to allow shorter term what are being deemed flash incarcerations as part of the division's graduated sanctions in lieu of the first 30-day temporary revocations of parole. Here are the numbers provided by Clark County Detention Center since the law's inception. I will also add that we received data from Washoe County Detention Center subsequent to finalizing this project, and they are as follows. Since July 1st, 2023, they have booked 94 times total for the flash incarceration knocks. This is a visual from the Nevada Department of Corrections portraying all parole revocations and reinstatements, January 2023 through April 2024. So you can see that after the July 23rd date, you can see that the 90-day revocations actually did go up. Regarding Senate Bill 35, we submitted a report in March of 2024 with available data regarding fentanyl-involved incarcerations. At that time, we could only give a baseline for the number of individuals who would conceivably be eligible for conviction under this law if the crime had been committed after July 1st of 2023. And on the left, you see the excerpt of that report. On the right, with the prior data set, we could only look at offenders who had been admitted since July 1st under the NRS. But now we have updated data set from NDOC, and we can pull convictions with offense dates after July 1st. That information is on the right, and they could have been convicted under SB 35 NRS. A file review showed 3 of those convictions, the ones you see in orange, involved fentanyl or derivatives of fentanyl. Senate Bill 316 moved the collection of data regarding murders and voluntary manslaughter charges to the Department of Sentencing Policy. We received a total of 16 counties' data. They replied by the February 1st submission deadline. 8 had incidents to report, 8 without. We have been in touch with Clark County, and they are working to format and submit their data. When we have that update, we will give it to you. Some visualizations regarding that murder data that we received. This is the age and reported gender of homicide defendants compared with the victims. We have a comparison of reported race and ethnicity of homicide defendants compared to victims. And here's the available information regarding death penalty involvement and available final case dispositions. We do plan in the next year to have everything online, and so that the respondents will not be able to move forward with leaving blanks. So we'll have much better information going forward. This next slide is a representation of the Department of Sentencing Policy's prison population projections. Please note these are not the JFA numbers. This was a project that NDSP undertook. Current NRS requires an outside entity to provide these projections, but we wanted to show some of what our data capabilities are. This new system that we have for projecting can be used to forecast how proposed changes in sentencing laws may affect NDOC population numbers for proposed legislation. And that does move us into data. I'm going to move quickly through some NDOC population information because that is our biggest data set. You see here NDOC population on age group. The largest portion of NDOC's offender population are offenders 30 to 34 years old. They make up 17.5% of the total population, which is at the point of this slide, 10,643. The smallest portion is made up of offenders 70 years and older at 2.28%. The NDOC, like many other statistical agencies, follow the standards on race and ethnicity set by the U.S. Office of Management and Budget. These standards guide how the federal government collects and presents data on these topics. Per these standards, race is broken out into 6 different categories seen here, and the ethnicity into 3. The top 3 largest portions of the population are represented by white, not Hispanic or Latino offenders at 34.63% of the total population, followed by black or African American, not Hispanic or Latino offenders at 30.8%, and then white, Hispanic or Latino offenders at 19.83% of the total population. This is the NDOC population by felony category. The largest NDOC population is made up of Category B offenders at 53.3%, followed by Cat A offenders at 28.94%. In this graph, we will see NDOC's population broken up into each offender's most serious felony category, and those 3 broken up into 3 different categories. I want to define here that an NDOC booking means that in the context of this presentation, it encompasses any convictions at the time of and subsequent to an offender entering NDOC custody. An offender could begin their booking with 1 or more judgments of conviction and potentially could add judgments of conviction to their booking once it has already begun. One way this could happen is if an offender is still pending sentencing from 1 or more charges when they enter NDOC custody, or if they are convicted, these sentences join the original booking and may add time to their original maximum. Another way is if the offender is paroled to the community but receives new charges. These charges join the original booking and may similarly add time. The booking ends when all convictions have been discharged. If an individual is convicted of a new crime after they have been discharged, then a new booking is created. So you can see here that the darker blue are people who have never left NDOC custody. The lighter blue, they have left at least once. Next, we have NDOC population by most serious offense group. 49% of the population is comprised of violent offenders, followed by sex offenders at 16.72%, property offenders at 12.33%, drug at 5.75%, DUI at 5.04%, and others at 11.17%. Now this is a visualization from our NDOC dashboards available on our NDSP website. Comprehensive information regarding the NDOC population and trends can be found here. This is the NDOC total population by age. Overall, the NDOC population has experienced a decrease in total population size. It went from almost 14,000 in 2017 to hovering just above 10,000 in 2021. Since 2021, we have seen a slow but steady increase to the total population. This analysis looks at the proportion of the population each group makes up to see how the population group is trending over time. Our department has been asked to analyze the proportion of the population that is made up of offenders 55 years and older. What we can see here is that over the last 7 years, the aging population in proportion to the total population has grown by 2.36%. The next few slides cover aging population. The U.S. Department of Justice, Bureau of Justice Statistics, defines the aging prison population to be the offenders aged 55 years and older. The Bureau of Justice Statistics found older inmates are more susceptible to chronic, costly medical conditions. They typically experience the effects of age sooner than people outside of prison because of issues such as substance abuse disorder, inadequate preventative and primary care before incarceration, and stress linked to the isolation and sometimes violent environment of prison life. In the upcoming slides, we will see how the aging population has compared to total population. Industry research estimates the cost of housing aging individuals at 4 times that of a younger population. For the less than 55 population, Category B offenders represented the largest portion of the population. When we look at the aging population group, we see that Cat A offenders represent the largest proportion at 58.33% in 2023. For offense group, together, violent and sex offenders make up 73.17% of the aging population in 2023. As of December 2023, roughly 70% of the entire aging population is made up of offenders 55 to 64 years old. Looking just at 2023, the largest groups of the aging population are offenders serving life with the possibility of parole offenders at 37.29%. The booking maximum incarceration length is less than 15 years at 20.74%. And it's offenders serving life without the possibility of parole at 15.91%. Offenders in this aging population who are serving life with or without the possibility of parole or a death sentence make up 54.73% in 2023. We will now talk about long-term offenders. This is a group of people that are being talked about a lot nationally. We were asked for data regarding Nevada offenders incarcerated more than 15 years. The next few slides will share information on individuals whose booking began on or before December 31st of 2008. You can see the top 10 offenses for the long-term offenders here, broken up. This is a breakdown of long-term offenders by offense group and felony category. This shows the previously discussed breakdown of whether individuals have left NDOC custody or have served time continuously. So again, the dark blue bar are individuals who have not left custody since they began. And this is the long-term group who have been there more than 15 years. This slide represents the number of offenses and their current booking, which means that 741 people are booked in on 5 offenses on their current booking. These are our next projects regarding data. The most exciting point I will mention is that NDSP has been in contact with the Office of the Chief Information Officer to explore creating a Microsoft SQL Server management database for the department. This will allow us to store, process, and query data more efficiently. We will be looking at medical costs for aging population. We do have a new data set from the DOC that gives us every offense. Prior to this, our statistical analysis involved their most serious offenses only, so this will give us a much bigger data set. We are going to do a deep dive into lengths of stay and a youthful offender analysis, and we are here to support the legislative session of 2025 with any research or data pills that you may need. Here's our contact information. Thank you.
Thank you for that. Does that conclude the presentation?
Yes, Chair.
Okay, for you as well, Mr. McCormick?
Yes, thank you, Chair.
Okay, thank you. Members, any questions? Not seeing any questions. I will go ahead and close agenda items 8 and 9. Thank you so much for your presentation. Next up for agenda item 10, we have a presentation by the American Civil Liberties Union, ACLU, regarding retroactive application of changes to criminal law. There will be a PowerPoint presentation. We have Atar Hasabullah, the Executive Director of the ACLU of Nevada, and Tatiana Smith, Policy Counsel, Policy Department, also with the ACLU of Nevada. And so once you have your PowerPoint ready and you're ready, you may proceed.
Good morning, Chair. Are you able to see the PowerPoint? Okay, great. Text comes so far. For the record, my name is Atar Hasibullah, first name spelled A-T-H-A-R, last name H-A-S-E-E-B-U-L-L-A-H. I'm the Executive Director for the American Civil Liberties Union of Nevada. I'm joined by my colleague today, who's a policy attorney with our office. It's also her first time presenting before this committee. She'll be seeing you all a lot during the next legislative session. Tatiana Smith, first name spelled T-A-T-I-A-N-A, Smith, common spelling. Today we're going to be discussing with you all the retroactive application of changes to criminal laws. I'm going to let Tia primarily share that information and be present for questions and answers. Just to lay out a little bit of context for why this specific issue is relevant to us, and we'll discuss impact momentarily, but our organization's worked on a number of issues where retroactive laws, legislation, or constitutional findings were made, including by district courts here in a matter that's now before the Nevada Supreme Court related to cannabis specifically. One thing I do want to note, and this is as a former member of the Sentencing Commission and someone who's been actively involved in the space for a number of years, is sometimes for ordinary people, the processes become confusing. And I'll give an example right now. We're discussing past marijuana or cannabis-related convictions, but what a lot of folks aren't aware of is that there's many ways to be prosecuted and convicted of a cannabis-related offense in the state of Nevada. It's not merely you are in possession of cannabis and that's it. It falls under a neat statute. Yes, that can occur. You can be charged with utilizing cannabis in public, and we recognize some of these offenses remain present, and that was part of the regulatory regime that was set forward at the time. But from a constitutional perspective, one of the issues that's come up with us, and the case that we currently have before the Nevada Supreme Court in CEIC and Poole versus Board of Pharmacy, relates to the scheduling status of cannabis for individuals who were charged and convicted even after the passage and enshrinement of medical cannabis into the Constitution of possession and sale of a Schedule I substance, namely cannabis, which still remains on Schedule I technically under state law, where most convictions end up occurring. And so those types of loopholes are rampant throughout NRS. I did want to lay that caveat out for why it becomes relevant to us, is, folks will end up seeing we're filing these cases related to constitutional issues and challenges there. It's specifically because those elements have historically been disqualified, and those individuals don't have the same access to relief because the way that the actual statute is described under NRS doesn't remain the same as the plain language of some of the bills that come there afterwards with respect to decriminalization. With that, I'm going to turn it over to Tia.
Good morning, this is Tia Smith. I'm going to start out this morning going through some of the highlights of the history of retroactivity in the law. Starting all the way back in 1798, this is when the U.S. Supreme Court first decided that retroactive laws that worsen punishments, also known as ex post facto laws, are unconstitutional, whereas retroactive laws that lessen punishments are constitutional under Article 1, Section 10 of the U.S. Constitution. Jumping ahead a little bit to 1977, this is when the court's starting to think about the different types of changes that can be made. So here the court decided that procedural changes don't necessarily violate the ex post facto clause unless there is a substantive element to it. So substantive change would be more along the lines of how a punishment is prescribed or the range of conduct that is prohibited, whereas a procedural change would be more along the lines of how a trial is conducted. And then we got the Teague rule in 1989. Here, the court decided that procedural changes generally should not be retroactive unless they fall into one of two narrow categories. The first is if it's more substantive than procedural. And the second, it's very specific. It is watershed rules of criminal procedure that are implicit in the concept of ordered liberty. This has actually only ever been invoked once. It was for the right to counsel. Fun fact there. And then in 2016, we had Montgomery v. Louisiana. This Supreme Court case actually focused on a 2012 Supreme Court case, Miller v. Alabama. And in Miller, they prohibited mandatory life without parole sentences for juvenile offenders. And so this 2016 Montgomery case took the Miller decision and made it retroactive. And then just a few years ago in 2021, the court was looking at that Teague rule. They said, nothing is ever going to meet this watershed standard again, and they just nixed that whole second part of the Teague rule. So an example of federal legislation that is retroactive is the First Step Act, signed in 2018. This took the Fair Sentencing Act of 2010 and made it retroactive. And so the Fair Sentencing Act addressed the discrepancies between crack cocaine and powder cocaine offenses. And so the First Step Act took all those changes and made it retroactive. Here in Nevada, we also have an ex post facto clause in our state constitution. It's Article 1, Section 15, and we have also had some discussions in our courts all the way back to 1865, which is when the Nevada Supreme Court first affirmed that laws can be applied retroactively within the state. And then we had another critical decision in 2008 where the Nevada Supreme Court found that when a crime is committed, the laws that are in effect at that time should be applied unless the legislature has expressed their intent to the contrary. So Nevada laws generally will not be retroactive unless there's something in the law that indicates the lawmakers wanted it to be retroactive. An example of a retroactive Nevada law is Assembly Bill 267, passed in 2015. This is the Nevada law that prohibits mandatory life without parole for juvenile offenders, and the post-conviction relief found in this bill was allowing these offenders to apply for parole after 15 to 20 years.
We go to, sorry about that. If we go to impact and we look at just three criteria for why these elements become important, I'll take them in reverse order because I think that legislatively there's been a lot of work done on each of these issues. On education, there's still barriers for certain categories and groups of people to be able to obtain financial relief, but interestingly enough, 70% of U.S. colleges and universities make some mention within an application process of requesting one's criminal history. With respect to housing, and this has come up multiple times, there's been disqualifiers over and over in the ability of landlords effectively to disqualify certain categories of folks from receiving housing, which obviously comes up in a slew of other ways. And employment and occupational licensing, as we shared this past legislative session in 2023, the VERA Institute has consistently rated us amongst the worst in the country for occupational licenses for those that have criminal convictions in the past. We're the fourth most licensed state in the country for occupational licensing and continuously, again, ranked the worst. That's a bipartisan criticism of our state that's existed, is we're not getting enough people to work, and part of that deals with the scrutiny levels that are associated with occupational licensing denials. There is no strict scrutiny application in every instance where a denial is made. In fact, our state licensing boards have been empowered effectively to deny these licenses at their own discretion without proper recourse for individuals who are seeking to be employed and coming off of public assistance in that regard.
So we do have some relief measures currently in Nevada law, which include record sealing. And so sealing a record refers to restricting access to it. It still exists. It's just generally inaccessible for many purposes. In 2019, Nevada Legislature passed the Second Chance Act, and this really helped streamline the process for sealing records of decriminalized offenses. So under this law, somebody has to write to the court in which they were convicted, asking for the record to be sealed. If the prosecuting attorney does not object, then the court should seal the record. We, of course, have a system for pardons here in the state that is governed by the Board of Pardons. Anybody convicted of a crime under Nevada law can write to the Board of Pardons and request to be considered for a pardon. And just to be clear, a pardon does not erase the record still exists, it just places a pardon on top of it. And then in 2017, a bill was passed about employment discrimination prohibitions. So public employers, it says that when public employers can start asking about criminal history and exactly what information they're allowed to take into account when they get that information. So we do have some safeguards here in our state, but let's see what some other states have done. In Colorado, they retroactively granted early release time to juvenile offenders who had been sentenced as adults for Class 1 felonies. In Delaware, they retroactively reformed their 3 strikes law, and they allowed for people who had been convicted under this law to petition for a sentence modification. In Maryland, they reduced the permissible sentences for various drug-related and nonviolent offenses. They also allowed people to petition for sentence reductions. In Louisiana, in 2017, they passed several criminal justice reform bills, and some of them worked retroactively, which included granting parole eligibility to some juvenile offenders who weren't eligible for, and also granting medical treatment furlough to some people with limited mobility. And then just earlier this year, the governor of Massachusetts mass pardoned tens of thousands of people who had been convicted of state-level misdemeanor cannabis charges.
And when we get to potential solutions, Chair and members of the committee, what can Nevada do in this regard? And then we'll be happy to take questions after this. And we listed 3 that stand out to the ACLU as an organization. Improve our existing record sealing structure as it stands. And part of the reason why we included that is we recognize our partner organizations, especially Legal Aid Center of Southern Nevada, has put in an immense amount of work here, but the burden oftentimes ends up falling on nonprofit entities to assist in record sealing or individuals to assist in record sealing without full-time and permanency associated with it. And we recognize that this is going to be an ongoing process as we look to make our system smarter. Notably, as we mentioned, in the state of Nevada, there's no expungement process. So you're still in a process of, and again, we don't have to go through the history of that. You all are familiar with why, but that structure as it stands right now does need to expand and be bolstered. The second would be to enhance and grow pardonability by the state, and that would be potentially an easier solution if we were looking at some of this and potentially enacting legislation that reformed part of what the pardons process ended up looking like. But the third one is probably the most tangible of these outcomes and the most realistic of the 3 that would be the lightest lift for everybody to address, which would be bolstering accountability measures. As it stands right now, many provisions under state law have been optional. We still don't have an Inspector General's office that would be responsible for providing oversight. I know that bill's been brought multiple times. ACLU is supportive of that measure. But the other thing that we discuss when we look at accountability measures is data collection has improved. We're grateful for the Department of Sentencing Policy and all the information Georgia and her team are able to provide consistently. But part of the challenge is that when we're looking at accountability measures, we still have a dearth of data in the way that data is presented, but not just on the back end when we're trying to deal with these issues. Example, again, going back to cannabis, we're looking at the sheer number of those that have been brought up on charges with respect to possession or sale of a Schedule I substance, and it's two-witted as cannabis because that's how it's effectively charged. They're going to fall between a Category E or a Category C felony. Again, that's a distinction between possession and sale there. And sale, under that provision, as I'm using it loosely, could mean the transfer of an edible from one person to another. That would constitute a violation under NRS because of the way the scheduling statuses have been historically. It is a loophole that has existed. It's one of the things we challenge, but because there's not clear data with respect to that, and oftentimes that data is not disaggregated, it's aggregated under this one lump provision, there's a lack of clarity there. Our viewpoint is if there was an Inspector General for the state that was actually involved in viewing these issues and looking into them consistently. And that function is different than that of the Attorney General, specifically because the responsibility of the Attorney General is to represent the state. The responsibility of an Inspector General would be to serve as an independent entity that was evaluating these issues where there wasn't an inherent conflict in representation of existing state policy. That individual might be able to look at that and make recommendations for disaggregation consistently as well, which we view as being a big barrier to actually understanding the core root of the issues. We understand that there's a fiscal note tied to almost every issue that's related to reform in that regard, but that office probably could lead the charge there. The other thing we'd mention up front too is that it's important to get ahead of the issues. I'll give an example of one that's in real time right now. ACLU issued a demand letter to the state, and there's a settlement agreement in place with respect to Davis versus Nevada, an adequacy with respect to funding in rural communities here in Nevada specifically. The Department of Indigent Defense Services created specifically for that purpose. Multiple times there's been requests to properly fund that entity so that there wouldn't be a reopening of that. Those issues thereafterwards wouldn't need to be relitigated. Post-conviction relief would not need to be sought, especially at scale. There have remained issues with getting that entity adequately funded. So our request is when there is an opportunity to prevent against something that would need to be dealt with later, primarily because of either an ineffective assistance of counsel claim or a law that's been changed, or simply because there's been a resource scarcity and the ability to provide access in that regard would pose barriers, it's important to resolve those issues in advance. So again, we make that request to this committee as well. We recognize it's not there, but if it does come up, there's a reason why we're mentioning it, and so we don't have to deal with this process later. With that, we're happy to take any questions the committee might have.
Thank you. Members, do we have any questions? Okay, not seeing any. I have one question, and it may be just more based on general assumption, but do we know if we were to move forward with this, how maybe the number of individuals that this would impact that are currently incarcerated or currently have records for past convictions? And also, I know we talk about cannabis a lot because that's pretty much the most obvious, nationally at least, the discussions about, but are there any additional crimes that could be impacted under this?
Madam Chair, with respect to the first provision, I think we can reach out to the Department of Sentencing Policy in terms of the actual quantifiable number, if there is one. It's hard to say, primarily because the data has not been disaggregated over time. There's a massive impact to understanding what the actual number of individuals who fell under specific provisions with some of these laws were. Again, when data is disaggregated up front, it's pared down and it's easy and presentable. It makes it easier for us to understand the full impact of what that might look like. When that doesn't happen, obviously it's not going to be the case, but we're happy to reach out to the department to see if we can get that information as well. With respect to the second part and what other items might be impacted long-term by this, when we've looked to decriminalization issue, and I'm not going to steal the thunder from our friends at Fines and Fees because I know they'll be speaking to some of these issues here momentarily, but if we're dealing with crimes that historically, or elements of crimes that have been rooted in socioeconomic status, namely poverty, and we're looking at some of the work that's being done both in Nevada, these last couple of legislative sessions, but also prospectively moving forward, it seems to be an area where there's a heavier focus on decriminalization of those aspects, and that could be something that ends up coming up. So what does that end up looking like long term? May end up impacting something like loitering, right? And if we're looking at another line and train of thought with respect to what we've seen with respect to sex work in Nevada, and many of the charges that have been brought there over the course of time, including solicitation. There are national efforts, and again, we don't know what will happen in Nevada, but those two seem ripe for us as a state that's kind of had a smarter focus on decriminalization long term and correcting the ills of the past to make sure that we're not running in, when we're looking at an impact perspective, to those same barriers on employment, on education, on occupational licensing, on housing. Those end up constituting a significant swath of the people that have been caught up in the carceral net over the course of time.
Thank you for that. And I know that some of the housing limitations are also federally mandated, which adds another layer of challenge for individuals. Members, any additional questions? All right, not seeing any. I will go ahead and close agenda item 10.
Thank you.
Thank you. Next, we have agenda item 11, which is a presentation on public defenders' fees, driver license suspensions, and traffic ticket payment. We will have a PowerPoint to accompany this, and we have our presenters today are Lisa Mosley Sales, Nevada State Director for Fines and Fees Justice Center. We have Nick Shepak, the Nevada State Deputy Director for Fines and Fees Justice Center, and Marcy Reba, Executive Director of Nevada's Department of Indigent Defense Services, although Marcy's not at the table, so I will, sometimes things change from the time that we get the information and the agenda's written, so I will let you two introduce who is co-presenting with you, and once you have your PowerPoint and everything good and ready to go. You may proceed.
Good morning, Chair Miller. Lisa Mosley Sales, Nevada State Director for the Fines and Fees Justice Center. And as you correctly mentioned, along presenting with us is Nick Shepak, Deputy State Director for the Fines and Fees Justice Center. And I would like to introduce to you all Ms. Alexandra Mork, who is a student at Brown University, a senior, who is interning with the Fines and Fees Justice Center and who has worked with us on some data analysis. So, you have the right to remain silent. Anything you say can and will be used against you in court of law. If you cannot afford an attorney, one will be appointed for you. Chances are we have all heard those words. Whether it was on one of our favorite law enforcement shows like Law and Order or another one, or unfortunately for some of us, in person after being arrested for minor traffic violations. What we are not told is that an appointed attorney may come with a cost that many people who find themselves in need of one are not able to afford. Nonetheless, courts across the state are assessing counsel fees and saddling indigent defendants with fees that they indeed cannot afford. I am going to pass this over to our Deputy State Director, Nick Shepak, to share more with you about that, and to Alexandra Mork, who you will hear more from later. I will remain at the table in case there are questions that you have of me. Thank you.
Thank you, Chair and committee members. My name is Nick Shepak, S-H-E-P-A-C-K. I'm the Deputy State Director of the Fines and Fees Justice Center here in Nevada. And today we're talking about counsel fees. So, as everyone is aware, Gideon versus Wainwright, which was in a Supreme Court decision in 1963, really established our public defender system throughout the country. However, in 1975, about a decade later, the Nevada Legislature passed AB 70, which allowed for the charging of counsel fees to individuals who received public defenders. Going back through the minutes of these meetings in 1975, the main concern was that individuals were not being truthful about their income in order to receive public defenders, and this was designed to discourage that behavior. That is not currently how the law is functioning at all. We are very good at determining individuals' indigency. And now what we have is a system in which, depending on which court you end up in, which judge you have, you may be charged as an indigent individual for your counsel. We've collected data from the majority of Nevada courts, and you will see the true roll of a dice that this actually is. Alex did an amazing job of putting this data together, so I'm going to pass it over to her for the next few slides to walk you through the data.
Hi, my name is Alexandra Mork, Mork spelled M-O-R-K, and I conducted a data analysis about all of the courts in Clark and Washoe counties because the Department of Indigent Defense covers the rural counties. And what we found is we collected data from the district, justice, and municipal courts. And while a few didn't provide data, most of them did, which allowed us to conduct a pretty robust analysis. And I attempted to standardize the information as best as I could, even though they provided some different types of information. So some courts might have provided the amount of fees assessed, while others might have only provided the amount of fees collected. And then ideally, the courts provided both. But the key takeaway from all of the courts is that the assessment of public defender fees in Nevada is very unequal right now. So first, there's a huge amount of discrepancies in terms of fees assessed between courts. So of the 16 justice and municipal courts that I examined, 7 charged public defender fees, 9 did not, and then 1, North Las Vegas, only charged 1 person. And of the rural counties, which are studied by DIDS, 4 charged fees, 10 did not. And so the result is a very arbitrary system in which defendants receive disparate treatment based on the court to which they're assigned. And then in addition to disparities between courts, there are also very large disparities within individual courts. So in Clark County in 2023, for example, there were 5 judges who assessed fees for over 75% of the defendants who were before them, but there were 8 judges who assessed fees on less than 5% of the defendants that came before them. And then we also had 5 judges who were somewhere in between those 2 polls and 2 judges who we had incomplete data on, and that's just within a single Clark County District Court in 1 year. To take another extreme example, in a municipal court in Sparks, they provided data about only 2 of their judges. For one of those judges, they charged a fee in 3 out of 913 cases before him, which means only 0.33%. For the other judge, he charged fees in 58 out of the 763 cases before him, which comes to 7.6%. And so that means that if you are in the Sparks Municipal Court and you get 1 judge, you are 23 times more likely to be charged a fee than if you get the other judge. So public defender fees, as I've attempted to illustrate, have large consequences, and they can trap defendants and families into cycles of debt, but they also do so without providing a significant financial benefit to the state. Across the board, even though fees are assessed, collection rates tend to be pretty low. Specifically, the district courts are responsible for assessing the highest amounts of fees, but in Clark County, the court only collected $27,900 in 2023, which is 8.17% of what judges assessed. And in the Washoe District Court, the collection rate was higher, but it was still $171,541, which is less than half of what judges assessed. For the justice and municipal courts, 7 out of the 11 courts and counties that charged defender fees in 2023 collected less than $10,000, and many of those collected less than $5,000. And as I mentioned, there's no centralized data system, so for some courts, we were unable to measure their collection rate percentages because we received only information about either the amount that was collected or the amount that was assessed, but not both. And moreover, for a couple courts, we received information about the total number of fees collected, but they didn't have disaggregated information about the amount of public defender fees specifically collected, so that was also a limitation on the analysis.
Thank you very much. And before I pass it over to DIDS, I'm going to, and this is Nick Sheepak for the record, I'm going to run you through our simple recommendation for this one. Essentially, it's to repeal that law and end the public defender fees, which would bring uniformity to the Nevada judicial system. It would end the unevenly applied practice. And for those individuals who are incarcerated after a conviction, they are not actually paying their defender fees. Those go into the deduction scheme at NDOC, and the families of the incarcerated are paying for those public defenders after their loved one has been incarcerated, so this would also end that practice. We asked DIDS to be here today, not because they take a position on this issue, but because their data and how defender fees are impacting the rurals and the funding formula we found extremely interesting and very important, and so we asked them to be here today to speak with you briefly on how these public defender fees are operating in our rurals and affecting that formula. I will pass it over to them now.
And Madam Chair, Lisa Mosley Sales, for the record, we will return with our second part of our presentation on traffic citations and accountability.
Thank you. And we thank Fines and Fees to be invited to this meeting here today. My name is Marcy Reba, and I serve as the Executive Director of the Department of Indigent Defense Services. With me today is Peter Handy, the Deputy Director from that department. We just wanted to come in and explain to this committee some of the background information that might help you determine whether or not this is an appropriate action to take. First, as you heard, in the 70s, the legislature created that ability to impose attorney fees to pay back for those indigent defense expenses. And there was really no consistency in how courts determined indigency until 2008, when the Supreme Court in 80 KT 411 defined what courts should use to determine, is a person indigent, should an attorney be appointed? And according to the court, A person will be deemed indigent who is unable, without substantial hardship to himself or his dependents, to obtain competent, qualified legal counsel on his or her own. Substantial hardship is presumptively determined to include all defendants who receive public assistance such as food stamps, temporary assistance for needy families, Medicaid, disability insurance, reside in public housing, or earn less than 200% of the federal poverty guideline. A defendant is presumed to have a substantial hardship if he or she is currently serving a sentence in a correctional institution or housed in a mental health facility. Defendants not falling below the presumptive threshold will be subjected to a more rigorous screening process to determine if their particular circumstances, including seriousness of the charges being faced, monthly expenses, and local private counsel rates, would result in a substantial hardship were they to seek to retain private counsel. So with the passage of the BIDS regulations, counties within 48 hours review a defendant's finances to determine if they are indigent. If they are indigent, counsel is appointed. And in 2023, this legislature passed the maximum contribution formula and placed it into statute. The maximum contribution formula is to assist counties in improving, in the rural counties, in improving their indigent defense services, where the state reimburses certain expenses over and above their maximum contribution. So it's similar to a high deductible healthcare system. Once a certain amount is reached, then anything over and above is reimbursed. You heard the amounts that counties are receiving from indigent defendants and what they're collecting. In the past year, the Department of Indigent Defense has reimbursed our rural counties over $3.2 million for their expenses related to indigent defense services representation. So there's a large difference of how much these counties are receiving from the state versus what they're able to receive from those individual defendants. And I've asked Peter here to kind of explain how we're collecting this data and provide that understanding to you and some complexities that attorney fees are causing for us.
Good morning, Peter Handy for the record. So yeah, I guess just to kind of give a broad overview, we have the maximum contribution formula, as Marcy explained. The way we provide the reimbursement to these counties is on that reimbursement basis. So they report to us their expenditures on a quarterly basis. We review those expenditures and ensure they're provided to or paid for indigent defense services. They provide any information on revenues they have that went to providing those services, including payments made for attorney's fees from defendants. So we obtain that information directly from the counties. It's usually just a lump sum line. We don't know whether those debts were incurred in a different year, but is that they're paid to the county during that reporting quarter. So when we actually make reimbursement to the counties, usually toward later in the year after they've exceeded that maximum contribution amount, we subtract those revenues from the amount they're being reimbursed to ensure that it's actually providing them with compensation for their hard costs rather than them being able to double dip effectively for those amounts. There are some limitations to that data. First, it's reported by the counties. We don't really have the functional capacity to audit all of the books from all of the counties. Second, like I said, we don't know when those debts were incurred by defendants. We just know when they're paid to the county, or at least when the county's reporting that they're paid to the counties. Clearly, the counties are making best efforts to track all of their expenses and revenues, but there's always going to be some sort of missing data or data that isn't consistent over time. I think a third part of this that really is a functional kind of issue with this is all of our data reporting comes from the counties. Our reimbursement goes to the counties. But in some circumstances, counties are providing indigent defense services to cities and municipalities within their jurisdictions. And there has been in the past a formula that this legislature changed just last session where they're getting $75 a case for providing those services. Now there is no cap at $75 a case. It's whatever costs are being incurred by the county for providing those services. However, this fee structure, this reimbursement structure of attorney fees, or the issuance of the fees to indigent defendants by courts can be remunerated to the cities. So if that happens and the cities are receiving these funds, we're not receiving that data from the cities because we don't collect that information. So potentially a county could be providing indigent defense services to the city. The city is then not, they're paying whatever the rate is either agreed upon with the county, or they might still be paying an older rate like that $75 a case for the services being provided by the county public defender. And those numbers might not be remunerated back to the counties when they're collected by the cities. So there could be some effectively subsidy happening by the county providing these services to the city, and the city is not providing these funds back to the county. Yeah. If you have any questions, please let me know.
Thank you for that. And we're having another switch out? Okay.
Thank you, Chair. This is Nick Sheepak from the State Deputy Director of the Fines and Fees Justice Center. The second part of the presentation here is on traffic citations and accountability, and I will be quick through this because I am aware of time here. So our current system, unfortunately, not due necessarily at all to the change to civil. Much of this existed before, but our traffic system right now is really a pay-to-play system in Nevada. For low-income drivers, if you cannot pay your traffic ticket in whole, you have to get on a payment plan, and at least 16 courts charge for you to get on a payment plan. Those fees can be as high as $50. This is a fee, another fee charged solely to indigent individuals. There's a bond to challenge your ticket. You have to put up the entire cost of what the ticket would be if you're found guilty in order to challenge your ticket. This is a major barrier. It's really a due process fee. While there are some workarounds with that for indigent defendants, they are unclear at most courts. And a single missed payment can result in a license suspension. However, on the flip side, if you are a higher income driver, many courts are now offering a fee to have your points reduced without any traffic school. So it's a I'll pay more to not be held accountable fee. You can hire a lawyer, which is fully in your right. But if you have the means to hire a lawyer, traffic lawyers are very good at getting points reduced on your license or your charges reduced. And you have the ability to pay that bond to challenge those tickets if you believe that you are not guilty of the offense for which you are accused. For one example, I'm using Henderson Municipal Court as an example for two reasons. One, they have this right on the front of their website. And two, because they have the highest payment plan fee in the state that we have identified. So an individual who gets a traffic ticket at Henderson Municipal Court can click a button to ask for a demerit point reduction and pay a $60 fee on top of their ticket. This would be no points recorded on their license, so they wouldn't be getting any closer if they were a dangerous driver to that driver's license revocation. However, same person in the same situation that is low income at Henderson would not have the ability to get those demerit points reduced, but they would have to pay $50 for the pleasure of being on a payment plan in that same court. Outside legal help, as mentioned, like Ticket Busters, they've been doing it forever here. They do a great job at no shade at Ticket Busters at all, but you can see that if you can afford to hire them, they have right on their website that in most cases, Ticket Busters will negotiate the fines without you going to court, without you earning points on your driver's record, and without any insurance increase. So again, we have a system in which if you have the resources to get the help, you're held to a far less accountability than if you are just having to get on a payment plan to pay for your ticket. What does it look like for low-income drivers? So this was not intentional. We passed SB 219 in 2021. Everybody who sits on this committee that was here during that session voted in favor of this legislation. The intent was that we would end driver's license suspensions for failure to pay. Also, failure to appear, now that they're civil, these two terms are fairly interchangeable. You have a court date, you either pay your ticket or you show up. If you don't pay, some courts view it as a failure to appear, others view it as a failure to pay. However, although it was mentioned that there would be an amendment with the decrim bill or this bill so that they would work together, it was the very end of that legislative session in the big rush that never happened. So driver's license suspensions resumed at the beginning of 2023. We've seen over 11,000 of them since then. So these are people who are missing payments. or otherwise unable to pay their tickets. Recent studies have found that a loss of a driver's license due to a suspension is almost $13,000 a year in lost revenue for that individual. Plus, we have unlicensed drivers on the road. A certain percentage of these people are going to still drive to work, to drive to get their kids, even though they have that suspended license. So that's a safety issue. However, on the other side, demerit point suspensions, between 2017 and 2021, Nevada only suspended 800 people for bad driving. And since the beginning of 2023, when we had these 11,000 failure to pay suspensions, there was 121 demerit point suspensions. We are over 20 times less demerit point suspensions than many of our neighbors. We have a system that is currently working it's essentially functioning as a revenue collection and not an accountability mechanism, which is very concerning. One of the problems is we don't have a unified court system, and individuals who get tickets they can get tickets all over this beautiful valley, and if you're in different courts, they're often treated as a first offense in each court, because they don't talk to each other. That we do have a centralized traffic citation system that the AOC built. It's a wonderful system. However, only 15 courts are currently using that system, mostly rural courts. But anybody who is in that system, no matter what court you're at, they will be able to see if you have a history of speeding, or if not just that it's your first time in that specific court. So our recommendations for working with traffic here is end that payment plan fee, mandate that payment plans are available. There's at least 17 justice and municipal courts that currently do not charge a payment plan fee. These are outdated fees back in the day when there was a physical file with your name on it and you had to write a check and there was a copy of a check. There was a lot of staff time that went into allowing people to be on a payment plan. These are all electronic now. Most people are making payments from their homes or their phones. We should end the driver's license suspension for failure to pay, as we did in 2021, and we should really be focused on holding those dangerous drivers accountable. And we should end that bond fee, which quite frankly might be unconstitutional. It is a fee to enter into due process, and it's a major barrier for our low-income Nevadans to seek justice if they feel they have been wrongfully accused. And so with that, we have a slide full of resources. There's links here. These have been provided to you. There's some, if anybody's interested in learning more, but at this point, we will take any questions on either part of the presentation that the committee has. Thank you very much.
Thank you so much for that, and to everyone who shared in the presentation. Members, do we have any questions for anything under this agenda item? Assemblywoman Cohen?
Thank you, Chair. I do have questions going back to the defender fee portion of the beginning of the presentation. What's the collection process like? Is there a collection process for the court system as far as how they're getting the funds back, what they're doing to get the funds, and what the cost is to the court system for collecting the funds?
Nick Shepak, Nevada State Deputy Director, Fines and Fees. Thank you for your question, Assemblywoman. So because we do not have a unified court system, collections are handled individually by each court. Some courts will use a county collection system. Some courts have their own collection systems. It's the same type of system they would use to collect any other court fines or fees. It is very likely that with these low numbers that it is costing more in many courts to attempt to collect these fees than you're actually receiving in the fees. And then for individuals who are sentenced to prison time, there is a mechanism set up through a deduction scheme for anybody who has money deposited on their books by a family member or has a job and gets money deposited on their books from work. A certain percentage of all of that money is taken out to pay court fines and fees, of which these would be included. I hope that answers your question.
Thank you.
Thank you for that. Members, any additional questions? Okay, not seeing any. Thank you for everyone that presented under this agenda item. And I will go ahead and close agenda item 11. Our next agenda item is agenda item 12, a presentation by law enforcement on the fees charged for body camera footage and public records. So we will have 3 co-presenters. Is it okay if we present all once under the agenda item? Great. We'll have Captain Joshua Martinez from Las Vegas, from the Office of Intergovernmental Services from the Las Vegas Metropolitan Police Department. We have Eric Buck, the Deputy Chief of Police from Henderson Police Department. And we have Shannon Hardy from the Division Manager of Administrative Services Division from Washoe County Sheriff's Office. There is a few PowerPoints that City of Henderson and Washoe will be presenting, and there are also handouts from Las Vegas Metro and City of Henderson as well. And so I am assuming, Ms. Hardy, are you there in Carson City, or are you on virtual?
I'm actually, sorry.
Are you virtual? Yes.
Hi.
Okay.
I am virtual. Sorry, I'm off usually today, and I'm in Napa.
Oh, well, where we all want to be right now. So thank you for taking the time in one of the most serene places in, that I can name. So, all right, whenever they're just working on getting their PowerPoint up, and it does not matter to us which order you present. So,
How about, can I go first, you guys?
Yeah,
You guys mind?
yeah.
I
was waiting for them to say no. Just sit there and look at us while you're in Napa.
Go. I'm going to share my, allowed to share, let's see, allowed to share screen, and I'm going to put the presentation up.
Yeah, we're looking at the one from Metro. Do you have a separate one?
Oh, I had one, but it's okay.
We have time if you need to find it, if you want to locate it. It's just we're
I have
not,
mine,
we don't. Can you share your screen?
Yep. Can you see that?
Not yet. We might lose you visually, but that's okay. But we still see you. We don't see your screen yet.
Okay, I said share screen. Let's see. Try this again. Share screen. And did you get a handout or a copy of the presentation?
We do? Yeah. Yes. Yeah, so why don't you just go ahead and proceed and we can look it up.
Yeah, sounds good. Okay, so
It's not working.
You guys can see me, but you can't see the screen, correct?
Correct. We can see you, but not the screen.
I'm just going to go ahead because you already have a copy of it. So request for information. I put a few stats together and some different information. So the Washoe County Sheriff's Office currently is using our GovQA system. So per NRS, there's a certain amount of time that we have to respond to these requests. So this system sends out the response to them immediately when they sign up for a request, which is done through our website. There's a link that takes you straight to GovQA. As you can see on the stats there, the requests for information, we had an increase of 60% this year. So our fiscal year, we're at 8,048. I have no staff for this either. I have one person that does body-worn camera, and I'm using a supervisor to handle the other requests. The system allows for tracking and responding to requests. It has a request for information, body-worn camera, and then we also track all the subpoenas that we get in. And even though subpoenas are court-ordered, they're asking for all the same information. So, they want all the videos, the photos, the emails. So it's all very, very, very time-consuming. Like I said, there's been an increase of 60% in requests. These requests can be simple. So we could get simple ones that's just like a report or a citation or a booking photo. And those we can get done pretty quickly. We can get those done in about 7 days. But they're not all simple like that. Many of them are emails, visits, photos, phone calls, body-worn camera. They want all the video from our fleet, dispatch logs, audio. Sometimes they want all of our contracts. They want murder cases. Currently, I have one that it's been open for about 58 days. We have a media company who keeps requesting everything on 5 murders. So we're trying to get everything together for 5 murders to give to a media company so they can post it on the internet. And we only have 1 staff member for this. We have requested yearly and above base positions to get positions. I thought perhaps I would get 3 positions this year, and I got none. Additionally, we use light duty deputies to assist. So if we have anybody that's on light duty, I bring them in to try to assist to get these done more quickly. But then again, we have to train them what they're looking for. It's not as easy as people think. You need to know where to find the information, and everything has to be redacted. That's the part that's really hurting us right now. I'm going to go on to the next slide. It's just the body-worn camera request and redaction. Body-worn camera requests have increased 121% since last year. And I have one person, I've purchased additional software to make it a little easier for her to get that done. But for every 10 minutes of a video, it takes 1 hour of redaction. And a lot of our stuff runs through legal. So that's very time consuming as well. Media groups, I talked about that. We have just seen an increase with the media groups who post body cam footage on private people, victims, witnesses, and it's for profit that they're doing this. There's no legal mechanism for the private individuals involved in a record that requires them to be notified of the request. So if somebody's in a video, there's nothing that says that they have to be notified that we're releasing this to someone. It has become so time consuming to redact all of this information. I don't know how we're keeping up with what we're doing right now. I have nothing on the fees. I think that was some questions. The county does have a, not the sheriff's office per se, but the county does have a fee schedule. I have put in for 6 ever to charge someone, and nobody has ever paid it. So that's it. Any questions?
I think the first one before we begin with questions is if you could share that fee schedule. Do you know how much it is
I don't have it on. I know exactly what it is. I have a copy right here with me. So the fee schedule with the county is personnel costs shall be charged at the minimum of the hourly rate of an office assistant. So it's our lowest position there is with the county. And I think somebody said it was $24. They just had the corn ferry, so I think that went up a little bit. It was $19.96. And they have it here that the first 10 hours is done for free, but after that, they would be charged. So another example, I can give you one more example. We have 40.96 hours of video right now, 2,185 photos. That's just for one request that somebody's asking from us, which is an estimated of 248.76 hours of work for my one staff member to do. We're getting ones like this. It's insane. We can't keep up with this demand. And then, like I said, it's 10 minutes of video. It takes an hour of redaction because we have to redact everybody's faces.
We're not just charging for the redaction of it. So you're saying the first 10 hours of work would be free, or labor that it would take, and then after that we would be charged, let's just say the $24 an hour, and that would be right. However many hours that it took in order to comply with the request. So this was 248
hours. Yeah.
So 248.
Hours. We'd give them 10 hours free, and then we would charge. We have not done that yet.
Okay, you have not done that yet, but that's kind of what the policy is right now, is written.
That's what the policy is with the county, yes.
Okay.
There has to be something put in place so that we can't keep up with this. There's just no possible way. And then everybody's angry because they're not getting their information they've requested. They don't realize that we have to, per NRS, we have to redact everything. And we don't have the staff to do it. And you should see how many we have. It's insane. So we're trying to keep up with it.
Okay, thank you for that. We have some questions from Vice Chair Scheibel.
So let me start by asking if the Washoe County Sheriff's Office is prepared to support a bill to remove the redaction requirements from the NRS.
That would probably be something I need to discuss with the sheriff, but so doing completely no redaction. And I think that would also have to go by associations because of police officers.
Okay, well, I would appreciate an answer to that because, you know, you presented us with a problem that you're saying that your office can't possibly.
I apologize because they threw this at me like in 2 days and I threw this together. I had no idea what I was even really coming to discuss or what anybody wanted from me. I would have been more prepared if I would have known. So I apologize.
That's okay. I'm just, you know, I'm just trying to solve the problem that you presented to us.
I will get an answer for you on that one.
Thank you.
No, I will ask that.
Thank you. And I'm also interested to understand a little bit
Any other
about
questions? Sure, and I will get an answer back to you guys.
I don't know if our audio's off or something. So I want to understand a little bit about the transition from the days pre-body cam to the days post
I lost you there
body
for a
cam.
minute.
I'm going to try to let it catch up. So I'm wondering, I understand that today you have one staff member who's responsible for providing.
So before the bill was passed, we were getting simple. Is it not working? Can you guys hear me?
We can hear you. I think we just have a delay.
I don't know why this is unstable now. Okay.
Okay.
So what I got, I only heard part of what you said. As far as the body-worn camera, how things have changed over the years?
Yeah, and more specifically, I think I'm understanding that there's one person who's responsible for providing body camera footage to both the
Did you guys hear
prosecutor's
me?
office.
On that.
Okay. I guess I'll follow up offline.
Yeah, we appreciate that there's
Are
some.
you able to hear me?
We can, but we think there's a delay. You know, maybe you're kind of going in and out where you are at, because even when you respond, it's not necessarily matching the question, so the timing's off. So Vice Chair Scheibel said she'll go offline with you, meaning, yeah, she'll contact you or email you or something like that.
Okay. Yeah, and I would say, yeah, we have one person for the body-worn camera. She's the only one that knows how to use the software, and but it takes so long, and so many people are asking for those requests. So,
Okay, so thank you for that.
Okay.
So
yeah, I
we'll
don't
just
know.
go.
I'm sorry, you guys.
Yes, thank you for that. And this, of course, is open to any members that will, that may want to contact you directly offline for these
That would
questions.
be great. If you just send me any questions that you have, any ideas, and I will, I'll respond back to you.
Okay, thank you so much for that. Thank you.
I'm sorry, you guys, this was not good.
We appreciate that. Thank you so much for joining. With that, we'll move on to our next two presenters, and you may proceed however you choose to proceed. I see, yep.
Okay. Good morning, Chairwoman. My name is, and members of the committee, my name is Josh Martinez. I'm a captain with Las Vegas Metropolitan Police Department. I oversee the Intergovernmental Services Office, and I have our Assistant General Counsel with us today, Matt Christian. He's going to talk about the topic of public records and body-worn camera and the fees associated and how our agency handles those. And I'll support him with any questions that the committee may have.
Yes, good morning again. For the record, Matthew Christian, Assistant General Counsel for Las Vegas Metropolitan Police Department. Very happy to be here today to speak on one of my most favorite topics, public records requests. Just to give a little bit of context, we can go to the next slide. Back in 2019, due to increasing demand, as well as the sheriff's dedication to transparency, we stood up a brand new public records unit. That unit is managed by one full-time sergeant, and it consists of 2 separate sections. Next slide. Those 2 sections are the public records section and the body-worn camera section. So on the public records section, they handle your traditional public records requests that would be for, again, traditional written documents. They also handle requests from the media for your everyday arrest reports and booking photos, which there are a lot of those. Every day we can look in the paper or watch TV and there's news about most current arrests and booking photos. So the public records section handles that. The body-worn camera section handles all public records requests for body-worn camera, but they also handle all requests that come in through civil subpoenas. And as I think our last presenter suggested, those are sort of interchangeable. We have a lot of civil litigants that will send us public records requests for body-worn camera, but they'll also send civil subpoenas, and it just sort of is interchangeable. The reason that we do the body-worn camera request that way is not only because that it's interchangeable, but there are so many requests that are coming in for traffic accidents. So it's become very common if you're in civil litigation or if you're just in the insurance claim adjusting process, there will, I think, always be a request for our video, because you never know if someone admits that they're at fault or admits that they're not injured. So it's sort of become a check the box to get the video when it comes to traffic accidents. And then the next probably largest volume of requests for the video is from other types of personal injury actions. For instance, if there's a shooting at an apartment complex, then the resulting litigation will mandate that our records about the investigation, including body-worn camera, would somehow be produced. This slide also gives a little bit of context for how many requests we're getting. So on the traditional record side, you can see the volume has pretty much doubled in the last couple of years. The body-worn camera requests have stayed the same, more or less, but I would just say that the volume of the footage has increased, and so that's making it more and more difficult to keep up. The officers are wearing their cameras or having the cameras on longer, and then any given request will be for more and more information. So even though the numbers are staying the same, the amount of work is definitely increasing. So the next slide is just another way of looking at the numbers. It reflects the total number of requests that we got last year. This one also breaks down how many are from the media versus not media. So as you can see, about half of the requests are from the media. This bar chart also sort of demonstrates that some requests we have a category called canceled. What that represents is that there's a significant number of requests that come in that are ambiguous or very overbroad. And so what our staff does is they'll interact with the requester, trying to either pare down the request or clarify it, and then it'll end up showing up in our system as canceled. Getting back to the staff, I think on the last slide, I didn't mention how many full-time employees we have devoted to this. We have 6 civilians that handle the traditional records requests, and then we have 7 full-time police detectives that handle body-worn camera requests. So it's roughly the 14 full-time employees. So the next slide is our charges. This slide really is focused on body-worn camera requests. So we do charge, but it depends on what you're looking for, what the nature of the request is. So for a large number of requests, there is no charge. For instance, if it's a matter of widespread public concern, then we don't charge anybody. We just upload the video onto YouTube. So I put some recent examples that I just thought of off the top of my head. You know, the recent shooting at the Prince Law Firm or the UNLV shooting. Nobody has ever had to pay for that sort of video because we recognize that the public is highly interested in that, and so there's more than one request coming in for it, and so we just put it up on YouTube. That's sort of reflective of our longstanding policy on critical incidents. I think we all know that after an officer-involved shooting, we have the sheriff's assistant will do a press briefing at 72 hours, and the most relevant video is always showed at that briefing. However, we do charge for other body-worn camera requests. Namely, these are sort of what I mentioned before. If it's a subpoena or if it's a sort of one-time request that only one person is asking for, then we do charge an $83 per labor hour fee to process the video. That video is based on the labor burden, the actual labor burden to pay the detectives. It's their salary and benefits. It comes out to $83 per hour, and we charge the actual amount of time that it takes to process the request. We feel that it takes about 4 hours per every hour of video. We used to charge an estimate, so we would multiply 80 by 4 to come up with 320 per video hour. But really the more accurate way to think of it is that it's $80 per hour of labor to process the video. Sometimes it takes longer than 4 hours per hour of video, but sometimes it'll take less. One thing that's not reflected on this chart that I thought of afterwards is we also don't charge for your everyday routine requests for arrest reports and booking photos. So I really could have had another column on there. The law permits us to charge a reasonable fee for an arrest report or a booking photo, but we've never charged the media for that sort of information. The next slide just reflects the amount of revenue that the Public Records Unit brought in from this effort last year. You can see that it's about $400,000. It costs about $2 million to operate the unit with all the employees in it. The $400,000, the absolute vast majority of it will be from insurance companies and personal injury attorneys or defense attorneys seeking video relative to their civil lawsuit or their claims that they're trying to adjust. I know the committee is interested in turnaround time. This is really very highly dependent upon exactly what's being asked, and so it ranges wildly. Again, your everyday request for an arrest report with the booking photo, we're going to be able to respond to those either the same day or within a couple of days. But on the other end of the spectrum, right now we have one particular request from an attorney who wants every report of every incident that ever happened at a particular apartment complex for a 5-year period. So there's literally, I believe there's thousands of incidents that have happened at that particular location. So we estimate that it'll take many months to respond to that request. The attorney is more than happy to wait several months and was also more than happy to pay a reasonable fee for the labor expense incurred in responding to that high volume of requests. Next slide is about just some of the challenges that we're facing. There's no question that the number of requests is increasing. There's no question that the breadth of the requests are increasing. We might get a request for every single email between the sheriff and anyone on his executive staff for an entire year. So, that's not uncommon, or they could even be broader than that. I mentioned earlier that in terms of body-worn camera, there's just more footage. And with the volume of footage, there's an obligation to go through and redact it. So it's just taking longer. So we are getting a little bit further behind than maybe last year at this time. The other challenge really is the redactions. And, the redactions are really a big challenge. We run across people on the worst days of their lives, right? This is not records from the assessor's office. These are police records. It could be a domestic violence. It could be a gruesome car crash. It could be a murder. There could be witness statements. There could be people revealing the most intimate details of their life. So we take our obligation to redact. It could be criminal history information that's recorded on the video or recorded in our records. So we take people's privacy interests very, very seriously. And there are certain statutory requirements that we have to redact certain things. But there's also the common law that the Nevada Supreme Court has endorsed in terms of privacy interests. There's also our law enforcement interests as well. It's very common for us to get requests for an entire file. It could be a homicide file, for instance, but we're still even investigating the homicide. We haven't even finished the investigation when we're getting public records requests for the witness statements, for the body-worn camera. So that poses a challenge in terms of the integrity of the ongoing investigation. And so for certain cases, we feel that in order to protect the case, it would be justified to redact or withhold records even, depending on the circumstances. So the need to redact is very apparent, and therefore the labor that's required to make sure that we protect those interests is just something that we take seriously, and that's why we have so much staff devoted to it. So with that, happy to answer any questions. I'm also authorized to extend an invitation if any committee member would like to come to Metro to view our public records unit. We're very, very proud of it. We have devoted a lot of attention to it, and we'd be more than happy to give you a tour and show you our process that we have. And so with that, you can always reach out to me if you would like to take a tour.
Thank you so much for that. Members, any questions? Vice Chair Scheibel?
Thank you. I do have a couple of questions. And first, I just want to say that I think that you had an excellent presentation, which answered a lot of my questions. And I appreciate the professionalism of LVMPD with their public records department, because I think it is important to have the staff, the training, the time devoted to that public-facing part of your obligations. And so I did want to talk a little bit about the redactions, because I can appreciate, having watched hundreds of hours of body cam myself, that it's very hard for us as legislators to write specific rules that explain what does and doesn't have to be redacted. And I think having detectives do the redactions is an excellent policy, because they have that training and that experience to know what is truly personal information versus, all of us walk down the strip or through a grocery store every day and our faces are caught on camera, and we're not entitled to have our faces blurred out in every camera that captures us. But if we're the victim of a sexual assault and we're talking to an officer about it, absolutely, we have a right to privacy there. So that's my very long context to ask you, in Metro's experience, are there areas of the law where you're getting slowed down because the statute requires redactions that you think maybe aren't serving the purpose of actually protecting people's privacy?
Again, Matthew Christian for the record. There are certainly areas of the law where it's not clear what should be redacted or not. There are certain areas that are very, very clear, right? So if we, this is very common for a body-worn camera to capture the screen of an officer's patrol vehicle. That screen will have the scope printout sometimes of the subject. So if the public, if just a miscellaneous member of the public is asking for the body-worn camera, the statute's clear. We cannot provide that criminal history just to anybody. So that has to be redacted. A sex assault victim's identity has to be redacted. There are other areas, though, that are not that clear. So, for instance, we always redact images inside of a home. We feel that the case law is clear enough that we all have a very high interest in the privacy of ourselves and our own homes. And so but we have a lot of video where the officer is invited into a home or must go into a home. And so we do redact that. However, if you're in a divorce, I'm just giving you the most recent example that's coming to my mind. If you're in a divorce and there's a domestic violence incident between the husband and the wife, and we receive a subpoena from the divorce case seeking the video from inside the home, then we're going to be more likely to leave it unredacted because there's a particular need for it for the purposes of that case, and theoretically it wouldn't be disseminated publicly. So there's a lot of sort of gray areas and nuances. The UNLV shooting, that's sort of that's also coming into my mind right now. There's so much video of these victims, students, who are being cleared from buildings with terrified looks on their faces, with their hands up in the air. I know for me personally, I wouldn't want my face broadcast all over the media. This is the worst day maybe of my life. The look on my face, to me, I would have a privacy interest in, but there's no statute that protects that. On the other hand, if we were interviewing someone because they had relevant information about the shooting and the case hasn't been even charged yet, we would be more likely to redact that because we would want to protect the integrity of the investigation. Or if we knew that the interview caught on camera is of someone who is at risk for their own safety, then we would have to think at least about redacting. So there are some gray areas, but we feel like we have it down now, pretty much. There's still questions that come up every day, but our staff now is pretty well in tuned as to what the department considers to be confidential, and what the law considers to be confidential, even though there is some gray areas.
Thank you. I think that answered my question, and I have a follow-up that you may have also answered. Do you make different redaction decisions based on who the requester is, and do you feel like the law is sufficiently nuanced to allow you to do that? Like you were saying, it might be different if the DA is requesting the camera footage from a DV incident and you want to handle the whole thing versus the nosy neighbor submits a public records request. Can you tell the difference, and are you empowered to make that determination about what's appropriate for this requester?
Great question. Again, Matthew Christian for the record. So the Nevada Supreme Court borrows heavily from federal law governing the Federal Freedom of Information Act. And it's very clear under federal law that a public records request must be treated without regard to who the requester is. Because if it's really a public record, then anybody would be entitled to it. So in my example of the domestic violence, if the nosy neighbor were asking for the video of the inside of the neighbor's home, then as a public records request, no, they would not receive it. But if the husband or the wife asked for that video as a public records request, they would be given the same answer because they're asking for it as a public records request. We in our system that we purchased in 2019 when we stood up our unit, every public records request is available on our website to anyone that wants to look at it. So that video we would not be able to make public because it's not a public record. So in that case, we would have to encourage the husband or wife, whoever wants this record, to issue us a subpoena. Because under the subpoena, then yes, we would treat it differently. I hope that answers the question.
I think that does. And just to clarify, those are both fulfilled by the same unit, though. The same 6 detectives are trained to prepare body cam footage for that subpoena or that public record request.
Again, Matthew Christian for the record, yes. In terms of body-worn camera footage, yes. In terms of records, we still are using our Records Bureau to respond to subpoenas, but they all get advice from me, whether it's the Public Records Unit or the Records Bureau. So I think we have it down where it's pretty consistent. Sure.
Members, any additional questions? My question would be, there seems to be a pretty dramatic drop in the body-worn camera requests from, what was it, 2021 to 2023? Couple more. And so, or 2022 to 2023. So do you have any idea why we see, I mean, that's a pretty significant, change, increase, and then decrease. So,
yeah, thank you for that question. Again, Matt Christian for the record. I noticed that myself. It's staying about 2,000 per year. I question that myself. These requests come in all sorts of different ways. So let's just say that you get one request. It could just be one request asking for every report and every video about 10 different events.
okay.
Or it could be, the media will do this. They'll want the arrest report, the booking photo, and all video from the same event. So I'm questioning whether or not our numbers are really, it's apples to apples, or whether we're really capturing everything. What I do know is that the body-worn camera unit tells me that they're falling further behind because there's more and more requests coming in from their perspective. So I would just kind of throw that out there. You really would have to do a really, really deep dive into the numbers to really discern year over year how many actual requests are coming in for traditional requests versus body-worn camera requests, and to sort of parse that all out. So but I definitely know what you are saying there, and I appreciate the question and the opportunity to try to clarify it.
Okay, thank you. Yes, with that variable considered, then the trend is probably consistent.
Yes.
Based on that. Okay.
Yes, absolutely. Because as you can see from the other column, the overall number of requests is definitely doubled from what it was 2 years ago.
Mm-hmm. Yes, significant increases.
And I guess I would say too that because so many of the requests that go straight to the body-worn camera unit are more along the lines of civil litigation requests, that maybe those would be the same over time. Because maybe there's the same amount of traffic crashes or litigations that are happening year over year. But I do know anecdotally that the workload is increasing.
Okay, thank you for that. Well, with that, thank you for your section of the presentation. We still have the City of Henderson, so I'm going to invite them up.
I just want to say, just for
Yes,
the record,
please.
we submitted the cost sheets too. So if you want to look at our breakdown for what we charge, we provided those to LCB, and they do change on July 1, so we provided that as well. And thank you for your time.
Thank you so much.
Thank you.
So closing out this agenda item will be the City of Henderson, and we have the Deputy Chief of Police, Eric Buck, and there will be another PowerPoint and handouts available as well. So we'll give everyone a few minutes to get resettled, and then just please proceed when you're ready.
Thank you. For the record, Mike Cathcart representing the City of Henderson. Just want to thank the committee and the chair for the opportunity to be here today. And I just want to introduce Deputy Chief Eric Buck, who will be giving you the presentation on how we handle our body-worn camera records requests.
Thank you. Good afternoon. For the record, my name is Eric Buck. I'm Deputy Chief of Police for the City of Henderson Police Department. The Henderson Police Department's Public Information Office currently handles all media records pertaining to the police department to include body cameras, dash cameras, 911 calls, photographs, radio traffic, and police reports requested by the public. This 16-month graph shows our PIO's ability to complete records requests within 5 days or less. It should be noted that over 90% of these requests to our PIO office are for body camera video. Body camera takes longer due to the complexity and certain considerations that have to be made. As you can see, our length of time for fulfillment over the last 16 months has increased. This is due to the increasing number of and complexities of the body camera requests. Public records requests come in from the media, citizens, lawyers, students, researchers, and commercial businesses. Between 2020 and 2023, the Henderson Police has experienced a 96% surge in records-related request submissions from 368 annual requests to 723 requests, which is the highest level of requests in our history. This highlights the growing demand from our community, which has been a challenge on the limited resources of our PIO unit. At this time, the PIO office averages 7 to 15 incoming records-related requests weekly, and on the body camera requests, it is not uncommon to have an estimated date of completion several months out or more due to the large amount of requests. As of today, we are working to fulfill 54 pending public requests in our PIO office. 49 of these requests are for body-worn cameras. A couple of months ago, we had over 170 requests in our backlog. To mitigate this backlog, the PIO office went through the entire list of body camera requests to ensure requesters were still actively seeking to fulfill their body camera requests. The vast majority of these customers were attorneys seeking these items for their civil litigation cases. Many indicated these records were no longer needed and their requests were closed as such. This cut our active caseload down to approximately 80 cases. The City of Henderson fee structure as it pertains to body cameras is the rate of pay for the employee working on the request times the actual work hours it takes to fulfill the record. The typical rate is $95.75 an hour plus a one-time $75 technology fee for body camera redaction services. There are two exceptions to this fee structure. The Chief of Police can waive the fee for any reason upon request, and anyone can make an appointment to come in and sit with a PIO. They cannot make any recordings of the video. However, they can review the body camera footage at no charge. If a request for body camera video is made, the first 30 minutes are free. The chart on the right side of this list is the Henderson fee categories which were submitted, and the body camera fees fall under the research fee. Video redaction takes place in two forms: visual redactions and audio redactions. While redaction software uses AI technology to assist in efficiency of redaction by blurring faces, there is still a manual component to ensure sensitive information is protected. The manual process is done frame by frame. Some considerations for redaction that must be observed are: on the video, the officer's faces must be redacted per NRS 289, juvenile faces under certain circumstances, sensitive graphic images, personal information. The body-worn camera is situated in the center of the officer's chest and will capture things like information on a computer, criminal history, information on a field interview card or an identification card. There is HIPAA content that must be considered. We have to do heavy redaction when an officer enters a hospital. Photographs in the background. There are reflections in windows that have to be considered. And then there are things that we have to unredact. Our software is famous for confusing the spotlight on the car as a face, so we have to go in and unredact it. And then we have to go in and review the audio on everything we release. So we have to mute personal information like date of birth, social security numbers, personal information. There may be privileged conversations. There could be sensitive radio transmissions, or any police tactics are taken out. As you can imagine, each and every video carries its own intricacies and factors that can affect the redaction process itself, such as lighting, movement, number of officers on a scene, reflections, and other content. Due to these individualized factors, a single 5-minute body camera can range anywhere from 15 minutes to many hours to complete the redaction process. Remember that manual redaction is done frame by frame. So to put that into perspective, our body cameras record at 30 frames per second. So some quick math is that is 1,800 frames per minute, or 108,000 frames per hour. Then you got to times that by the number of officers on scene that are recording. Quick snapshot of what our PIO office looks like. The Henderson Police Department's Public Information Office, PIO, is currently staffed with 2 full-time sworn officers. As of January 24, to assist with the growing number of public records requests, the office was supplemented with 1 part-time law enforcement support specialist from our police records unit to assist with records requests for reports. This employee works up to 19 hours a week. HPD's PIO office is responsible for responding to and the completion of all publicly submitted record requests for video, body cam, dash cam, 311 and 911 audio requests, and photo requests, in addition to all the police-related media requests for police reports, videos, audios, and criminal statistics. The PIOs also handle any other media requests like coordinating interviews, on-scene briefings, news releases, public service announcements, and monitoring and posting to all of our department's social media accounts. One huge concern that we have is from large commercial requests. The Henderson Police Department has received requests from large production companies for body camera footage and case reports. The cases requested are large homicide investigations that have sometimes taken years to solve and involve many officers. This can result in hundreds of hours of video which must be reviewed by the PIO team before being released. At 1,800 frames per minute, this request becomes overwhelming. In addition to the video, these requests include any 911 calls, photographs, reports, and recorded interviews that are associated with that case. These requests are coming in not just locally, but from across the world. Just this year, 2 large production companies requested all documents from a homicide case that Henderson Police solved. This request would necessitate a dedicated PIO officer to set aside all other duties to complete, impacting our department's level of service in all other categories fulfilled by the PIO's office. The Henderson Police Department values its positive relationship with the community, striving for transparency, cooperation, and providing premier services. While we aim to accommodate requests for body camera footage in a timely manner, there are several factors that can inhibit these goals. We queue our records requests on a first-come, first-served basis. There is no priority giving to any certain requester. Complex videos require more resources and time, as stated before. We encourage that the number of body cameras requested be thoughtful and concise to capture the required content for the requester in a timely manner. There are other pressing departmental concerns that take priority over the records releases, which divert our PIO resources. Examples are officer-involved shootings, large-scale incidents, city events, media releases on notable events, and unforeseen obligations. That concludes the presentation. Happy to take any questions.
Thank you for that. Members, any questions? Yes, we'll start with Vice Chair Scheibel.
Thank you also for your presentation. I think you also did a good job helping us kind of see the nuance, and I did not know that about going frame by frame and the number of frames in a second. It sounds tedious, if I may say. But I want to ask you the same question I've asked other presenters, which is whether the statute as it's written is, for lack of a better term, working for the Henderson Police Department, or whether there are areas that are either so unclear that it's taking more time than it needs to, or redactions that you think are required by statute that don't necessarily reflect the purpose of a redaction.
For the record, Eric Buck, thank you. That's a great question. Personally, I'm not one of the boots on the ground doing the redactions. I think it's a great question. I think we need to look at. I would like to take that question back to my team and run it by them and then respond to you in an email.
That would be great, because just to be clear, if there are ways that we can, narrow the scope of work by improving the statute, I think we're all open to doing that. And we also want to balance the privacy concerns that we've been talking about all day. The other question I wanted to ask, if I may, is also for you to clarify, is it the same employees who provide the public, specifically body-worn camera footage, as provided to attorneys and prosecutors, or do you have separate departments for those two?
For the record, Eric Buck, it's the same group.
Members, any additional questions? All right, not seeing any. Thank you for your presentation. I will go ahead and close agenda item 12. I recognize that people are probably getting hungry, but I also recognize this is our last agenda item before public comment. And so we're going to move ahead with our agenda item 13, which is the presentation by the Legal Aid Center of Southern Nevada on the sealing of criminal records in Nevada. We have Jonathan Norman, who is our statewide advocacy, outreach, and policy director for Legal Aid, and Ellie Rohani, who is human trafficking survivors' rights attorney from the Resilience and Justice Center. So please, when you are ready, I'll give you a moment to get your PowerPoint set up, and then please proceed.
Chair, members of the committee, thank you so much for having us. Jonathan Norman, I'm the policy director for the Nevada Coalition of Legal Service Providers. It's my pleasure to be joined by Ellie Rouhani. She was a former state court district judge, and she was also a assistant U.S. attorney prosecuting child sexual exploitation cases. We are very lucky to have her at Legal Aid Center. Today we're going to be discussing record sealing. And we're going to discuss three avenues to that clean slate: decriminalization, record sealing, and vacature. I think it's important when the public hears these terms, they only know record sealing, right? This is how I move forward. Even me, every time I see the word vacature, I swear it's misspelled, and I Google it. Even I think Microsoft Word thinks it's misspelled. So, and with that, I'm going to turn it over to our expert. So we have at Legal Aid Center and Nevada Legal Services, we have 2 full-time attorneys that only do record sealing. And then we have other departments like Ms. Rouhani who work on record sealing when it's a human trafficking victim.
Thank you. Good afternoon. Ellie Rouhani for the record. I wanted to start with the statutes, the statutes that are implicated and give you a broad view of what we're looking at. So the statutes that we work on sealing and vacature are set forth here. Can you click again, please? And it also includes 2 other subsections that are not commonly used, but are also included within the statutes with respect to reentry programs and certain controlled substance offenses. Nevada is unique in that we also provide for the restoration of civil rights automatically by statute if a person does get their record sealed or vacated. And finally, what Jonathan started with, which is the decriminalization of the offenses. And that's where I wanted to start. Decriminalization is set forth in 179-271, and this is I want to be clear, it's not a record sealing petition. It's done a little bit differently, and we haven't had occasion to use this statute often, but you heard earlier from the ACLU with respect to decriminalization, this is a much more straightforward process that doesn't require stipulations and things like that. So this is just a written request to the court, and the process is set forth here, and it's fairly delineated within the statute. So, getting to what Jonathan's talking about, what's the difference between record sealing and vacature? Vacature is a real thing, and it works differently than record sealing. And I like to think of it as record sealing is a Band-Aid that will cover the conviction and it will cover the court proceedings. It's like the proceedings never happened. Vacature is a little bit different, and it takes into consideration who it's available to. So vacature is available to human trafficking victims, so sex trafficking, labor trafficking, as well as victims of involuntary servitude. And vacature deletes everything related to the case, the conviction, and it assumes that the acts themselves never occurred in the first place. We do that by vacating the judgment and vacating the accusatory pleading. And this is more trauma-informed for our victims of trafficking because it gives them solace that their acts that they did under duress was a result of victimization and not their own volition. And so that is the first big difference between vacatur and record sealing. The next is that the record sealing statute can be used by anyone for any misdemeanor, gross misdemeanor felonies, with a few exceptions that I'll note in just a moment, and also for arrest. The vacatur statute is limited to only be used by victims of human trafficking and involuntary servitude. And then the last is, the biggest difference is that the record sealing statute available to typical candidates has statutory waiting periods of stay out of trouble. So nothing other than a minor traffic infraction during the statutory period. Those periods are between 1 year for misdemeanors and up to 10 years for certain Class A felonies. And that waiting period doesn't trigger when the conviction or the judgment of conviction is entered, but rather when the case is completely finished. So all parole, all probation, the case is closed with the court and the person is discharged. There's no more court involvement. Vacatur is different. There are no statutory waiting periods. Again, this is trauma-informed because victims of trafficking should have the right to rebuild their lives as quickly as possible. And so for any conviction related to the trafficking or sustained during the period of trafficking, there is no waiting period. So talking about eligible charges, with respect to record sealing, it's easier to talk about what's not included because that's how the statute is written. I wanted to note that rather than reading this slide to you, one of the things that I think is important is that the way that the Nevada Supreme Court has interpreted this statute is it's not what you would colloquially think about a crime against a child. It is only what is specifically delineated and notated within the statute to when the other statute's pointing to another place. So with crimes against a child, they're defined by particular statute. For sexual offenses, there are 17 specific offenses. And then with respect to the DUIs, that includes both if you're driving an actual vehicle versus a vessel. So it seems redundant, but the reason why is that it wants to be all-encompassing because there's a lot of statutes that a person could potentially be charged under. For vacatur, it's a lot more broad. And again, this is trauma-informed in the sense that trafficking victims, you would be surprised with the amount of things that they can get themselves in trouble with when they're under duress. The fairly common ones that you might think about are prostitution or solicitation for prostitution or loitering for the purposes of prostitution, so long as the person is not the actual customer of the prostitution. And then everything else other than a crime of violence. Interestingly, a crime of violence is not defined within this statute. It's included in a different chapter that includes general criminal definitions, and that definition is set forth here. There has to be the use or threatened use of force against a person or property of another person for it to be a crime of violence. The second subpart on this includes that there has to be a substantial risk that force or violence would be used against the person or property of another. I only wanted to note here that language very similar to subpart 2 has already been determined to be unconstitutional in 2 cases by the United States Supreme Court, specifically in Johnson versus United States in 2015 and Sessions versus DeMaya in 2018. But to date, in Nevada, that second subsection has not been challenged as being unconstitutional. You might be wondering why are petitions denied or what's causing the delays for some individuals. The first is, and most common, is that the person hasn't met the specific statutory time periods. So for a Class A felony that would be eligible, they'd have to wait for 10 years. So at year 7, if they come in and they're trying to get it sealed, of course they haven't waited that sufficient time period. The next is the definition of current that's set forth in both the vacatur statute as well as the record sealing statute. Says that a person has to provide their current verified records from the central repository. There's no definition of current. And so the general judicial interpretation in this state so far has been somewhere between 6 months and 1 year. And when I talk on the next slide about the time it takes, you'll understand why this becomes problematic for some individuals. Judges will maintain a judicial preference to have a prosecutor's stipulation or agreement that the records can be sealed. That triggers what was called a rebuttable presumption. So you all are familiar, you're past these laws. So the rebuttable presumption, if a prosecutor stipulates, or all the prosecutors involved would stipulate to the sealing of the records, it creates a presumption which takes the discretion away from the judicial officer. And so the judges appear to have that preference, many of them do. And the last is that prosecutors' offices do have these all or nothing stipulation policies. So if a person has one offense that is not sealable by statute, the prosecutor's office typically will not stipulate. I will note that there's a reluctance there with respect to that. But when there's human trafficking victims, they have been very gracious. They are willing to recognize the person as a victim, and so they have agreed to partial sealings on those instances, as well as the courts. This is the most important slide because I think that this is where the statute differs from practice. And so I think this is where I want to spend whatever time I have left. I'm not even keeping track. All right, here we go. Thank you. The first thing to get the process going is fingerprinting. The applicant would have to go to a local law enforcement agency or a private place to get a fingerprint card completed. Only one fingerprint card is needed. Then they would send that fingerprint card at step 2 to the Nevada Department of Public Safety, which is the central repository of the criminal records of the state. That, once it is the fingerprint card reaches there, the central repository will produce what we call a CHR, or a criminal history report, that is certified and dated. From the time of the mailing of the fingerprint card to the amount of time that it takes for the applicant to get that CHR certified back is somewhere between 45 and 60 days. Then the applicant will use the information that they get from the CHR, which would show them the arrests and convictions, some arrests, most convictions. They would identify every law enforcement agency that might have the records of their arrest or any other criminal records. Additionally, the applicant should check, sometimes they don't, but they should check every local court docket for additional cases that might not be reflected in the CHR. Once that big grouping of jurisdictions is identified, then the applicant would go to the individual law enforcement agencies within those jurisdictions to get the records of their arrest. That is done in a scope. So scope is the law enforcement agency's record of the arrests and convictions. You would be surprised to hear that the records of the state of Nevada often don't match the scope, and many of the records of the law enforcement agencies don't actually match the court records. So it's important to include all of these things so that we have a full view of all the things that need to be sealed. Obtaining a scope can take anywhere from a few days to a month, depending on the law enforcement agency. Then the petition is prepared. That petition, if it includes more than one jurisdiction, so just for an example, if the person would have a felony offense in Clark County, as well as an arrest in North Las Vegas or an arrest in Henderson, they would produce what we call a super sealing petition, where the statute would allow the applicant to submit that petition directly to the district court, which would have the jurisdiction to seal everything below it. Las Vegas Justice Court does not have the ability to seal Henderson's records. So if there are multiple jurisdictions, you would do a super sealer petition. And then of course, if there's only one jurisdiction, you would just do it in that individual court. The number of steps in this little bit depends on the number of courts to be sealed and caseloads, but that particular amount of time for the production of the petition for a pro se individual can be quite lengthy, and even for some attorneys, depending on workloads, it'll depend. Our process, where we differ in the legal aid process, is then we send our prepared petitions back to the individual law enforcement agencies to get certifications that the records that the applicant is trying to seal are actually eligible for sealing. The law enforcement certifications do overall expedite the process, and the step can take anywhere between 1 week and 30 days, depending on the law enforcement agency. After the applicant will receive those law enforcement certifications, then the petition would be sent to each prosecuting office in succession. What I mean by that is that because we deal in Clark County, so in the Clark County District Attorney's Office, they don't have access to Henderson's records or North Las Vegas's records. So the request has been made to us, get Henderson's stipulation, get North Las Vegas's stipulation, and then give it to us so that we can do a final sign-off. Every prosecuting office has their own process for review. It typically takes between 30 days and up to 4 months to get a stipulation from each of these district prosecuting offices, assuming that they give the stipulation in the first place. Next, the petition, all of the documents, everything we've collected along the way, the CHR, the scopes, the certifications, the stipulations, is all put together in the packet, and it is filed with the court. Now, once it's filed, the length of time that it takes to actually get an order depends on the judge, and we have 32 judges in Clark County. So 32 different timelines, 32 different ways of doing it. But once the court order is obtained, then the applicant has to take that order and send the order to each agency who might have the records. So everybody they identified in the CHR, everybody they identified in the scope, everybody they identified in the court records, they send that out, and those certifications that they've actually been sealed and those compliance letters trickle back in. And the applicant typically waits 6 to 8 months to get all of them back. The last one that we typically get back is from the Department of Public Safety. On average, from step 1 to step 9, the process can take up to 18 months. And for human trafficking victims, you have to understand that they carry the burden of that victimization with them every step of the way. And it is preventing them from rebuilding their lives with employment and things like that. And it's hopeful, but it's also very traumatic for them. Statutorily speaking, and I mentioned this at the beginning, the difference is by statute, the only thing required in the petition is the criminal history report. But in an effort to expedite the process to get the stipulations, we have modified our processes to make sure that it gets done as quickly as possible for our clients. The costs involved with this. The biggest thing that is the difference here between record sealing and for vacature for trafficking survivors is that last session, Assemblywoman Hardy's bill, AB 275, was removing the financial burden. What I will note is that I don't think it's trickled down all the way yet to all these various agencies that need to make their adjustments. The one organization that has made that adjustment is the state of Nevada. So the DPS form to get the criminal history report with the fingerprints has now been brought down to 0. And so we're working, but it hasn't happened yet, but we're working through that. There's 2 organizations here in Southern Nevada that will do record sealing for indigent defendants and also for victims of crime. That's Nevada Legal Services and us at the Legal Aid Center of Southern Nevada. And I turn it over to my colleague.
Jonathan Norman for the record. I would note that Nevada Legal Services is statewide, so they can do record sealing throughout the state. And also for Legal Aid Centers, a lot of our victims are not actually in Nevada. They may have moved on, but their crimes are here, and we'll help them seal their records no matter where they're at in the country if they're records that are from Nevada. And we're happy to answer any questions.
Thank you for that. What a great point to end that on, of clarification for folks that are not in Nevada. Thank you for that. Members, any questions? I don't see any questions. Thank you for that information. I really appreciate it, how you disseminated the information in a very basic level. I think it's often, regardless of whichever committee we're in, people speak in their professional jargon and they assume that everyone in the room knows what they're saying. And typically in this room today, yes, maybe not so much for folks watching online or who will watch it in the future. But again, that's why I speak at a 5th and 6th grade level, so that the average person knows exactly what we're talking about. And so I appreciate that, and your graphs and charts as well. So thank you for that. And with that, I will go ahead and close that agenda item. That was our final agenda item of presentation for the day. However, we do have our next agenda item 14, which is public comment. So we are returning, as stated before, to our second opportunity for public comment. Again, we ask that people keep their comments to 2 minutes. The phone number for those who wish to call in, again, is 888-475-4499. When prompted, the meeting ID is 890-323-8744, and then press pound. Someone from Broadcast and Production Services will let you know when it is your time to speak. So with that, do we have anyone here in Las Vegas that would like to come forward to present for public comment? Not seeing anyone. Is there anyone there in Carson City that would like to make public comment?
Good afternoon. Thank you, Madam Chair Miller. Tanya Brown, TONJA-BROWN, Advocates for the Inmates and the Innocent. I'd like to comment on the presentation given by Ms. Georgia Powers. I did speak with Ms. Powers outside just prior to her, or just after her presentation. Regarding the looking forward, the medical cost for the aging population and that information and all the data information that she had provided. And she did agree with me that there was some data that is not available, that should be available, and that should be something that should be looked into, and that is dealing with the nutritional value, the food that the inmates eat every day versus the cost of the medical. When the diet of the inmates being provided affects the outcome of their health, which ultimately results in health issues, their diet is a poor diet. I know they have a standard, but it raises, the older they get, the more it affects their health, their cholesterol, their heart, so on and so forth. And also, there's no data information on the kites the inmates put in for medical reasons. There's no data on the kite that was put in, how long it took for them to see a doctor, to be seen by a doctor, how long it took to get treatment, should treatment be needed. And there's no data on the length of the data and if it resulted in the medical conditioning worsening, which ultimately would cost more in medical costs. I have seen where inmates have gone days, months, and even years without any kind of medical treatment. Some have died because they didn't get the treatment. And it still continues to this day. And so this is something that we believe that this data would be beneficial to this committee in order to have a better understanding of the medical cost of NDOC when you are looking at the budgets and so on and so forth. Look at the kites, see the data, because it is telling. When you have a person who could be treated and it goes on for weeks, months, and even years, and then ultimately it winds up being something like cancer or a condition that was so easily treated, and now it's costing the state hundreds of thousands of dollars in medical costs. So this is something that I think should be included. Thank you.
Thank you, Ms. Brown. Is there anyone else there in Carson City that would like to make public comment? Okay, it doesn't appear that anyone else is approaching. So with that, we'll move over to the phones. Broadcasting, will you please open the lines?
Certainly. Thank you, Chair. To provide public comment, please press *9 now to take your place in the queue. Caller with the last 3 digits, 556, please press *6 to unmute. Caller, your hand is raised. In the assumption you are providing public comment, if so, please press *6 to unmute. Chair, the caller seems to be having problems unmuting their phone. The public line is open and working, and there are no additional callers at this time.
Is the caller, you can see that they're still actively online, though?
Correct,
And
yes,
they're
ma'am.
just-
They have raised their hand and are not hearing the prompt to unmute.
Right, let's just give them another moment or so because they are actually online.
Certainly, thank you.
Sorry, I was having
Caller,
trouble
you are unmuted.
unmuting.
Please proceed.
Yeah, I apologize. Anne Marie Grant for the record, ANNEMARIE, GRANT, sister of Thomas Purdy, murdered by Reno Police and Washoe County Sheriff's Office. I want to thank Vice Chair Scheibel for the suggestion of limiting redactions. The majority of redactions are of the police officers' faces. That's probably what's taking them the most time, is blurring officers' faces. Washoe County doesn't even have a body-worn camera fee schedule on their website, the county sheriff's office. In December of 2020, Sheriff Balaam tried to get the county commissioners to allow them to charge $200 an hour to redact body cam footage. Based on the fees I'm getting quoted, it's pretty much at that. At the time, Balaam apologized to the community, so I'm not sure what has changed in regards to him perpetuating the idea that he's for transparency and accountability. There is no uniformity in any of the fee schedules or in redaction processes. There's too much left to the discretion of the individual person fulfilling the request. There should be legislation regarding redaction. We need to change NRS 289, the peace officers' Bill of Rights, ASAP, because that is why they are blurring the officers' faces out on the body-worn camera footage. Axon has many tools that are available to these agencies to assist with redaction, skin blur redaction, smart tracker redaction. There is an add-on feature called Redaction Assistant, which can swiftly scan through the footage for sensitive information with real-time results. If you look at the fee schedules that were provided, many fees are unattainable for the average person, not just the indigent. I'm an average person, and I can't afford some of these fees. Fees should not be a barrier to transparency and accountability. I know how important those videos were of my brother being murdered when law enforcement killed my brother and lied to us and told us he just suddenly stopped breathing and was talking crazy, when in reality they had hogtied him and asphyxiated him to death. They always use Dawn Ray of Nevada, the Bradshaw, to deny requests.
Ms. Grant, can you please wrap up your comments? It's been over 2 minutes.
Yes, sure. Thank you. That's all I have to say. Let's hold them accountable and get some laws in place so that there's some consistency with body-worn cameras and the release of them. Thank you.
Thank you. Broadcasting, is there anyone else on the line?
Thank you, Chair. The public line is open and working, and there are no additional callers at this time.
Okay, then I'll go ahead and close public comment. Our last item, of course, is adjournment. This concludes our meeting for today. Our next meeting will be Friday, July 26th. So if you're looking for a June meeting, this kind of was the June meeting as well. So we will see you all Friday, July 26th at 9 a.m. Please remember to prepare any solicitation for bill draft requests and have that in by, what was that, August 7th at 5 p.m. And with that, this meeting is adjourned.